Please, sir. May I please, Your Worship? Yes. Your Worship, I beg to mention admission item number 1, Your Worship. In this matter, Your Worship, on the last occasion, I have sought a week's time to file my affidavit in opposition on behalf of respondent number 3. However, due to some inability, I could not file it. So I'll be filing it during the course of the day.
You are for
Admission item. Your Worship. Respondent number 3, Your Worship.
respond Z. Kulnu.
Yes, Your Worship.
Heard Mr. Z. Kulnu, learned counsel for the respondent number 3, who prays for some time to file affidavit in opposition on behalf of respondent number 3. Also heard Mr. Foseko Forte, learned counsel for the petitioner, who does not have any objection to the same. Hence, the prayer is allowed. Let this matter be listed after a week.
After 2 weeks,
After 2 weeks,
since
on
we're
a
filing
date-
today, I'll need some time to
Totally.
file reply also.
on a date to be fixed by registry.
Much obliged, Your Worship.
My lord, there's no interim. Can I let the interim continue?
The interim order shall continue till next day.
My pleasure, Lordship. Lordship, with the consent of the other side, I beg to mention item number 10, Lordship. I'm appearing on behalf of Mr. Limatoshi. I Limatoshi is the sole respondent.
What is your name?
El Sankam, Lordship.
Heard Mr. L. Santam, learned counsel appearing on behalf of Mr.
I
I.
Limatoshi,
Limatoshi, the learned counsel for the
sole respondent.
sole respondent, who prays for an adjournment. Also heard Mr. Moaz Zamir, the learned counsel for the appellant,
Lordship.
who does not have any objection to this thing. Hence,
Well-
the prayer is allowed.
May I brief for listing it on 13, Lordship.
Let this matter be listed on 13th.
13 of August. Next Thursday, Lordship.
What is the matter?
I'm challenging the succession certificate issued by the.
Okay, let the matter be listed on 13th August.
Much obliged.
Obliged.
May it please your lordship. Your lordship, I beg to mention item 3 and 4. Your lordship, kindly let this matter come up on 8 since the leading counsel is out of station.
What is your name?
Atsizo Kense.
For the petitioner,
Yes, your lordship.
heard Mr. Ezo. Heard Mr. Atsizo Kense, the learned counsel for the petitioner. You are for?
I'm for item number 3, petitioner, item number 3.
In WPC number, WPC criminal number 3/2026, who prays for an adjournment as the conducting counsel for the petitioner is out of session. The prayer is not opposed to by the learned counsel for the other side. Hence, same is allowed. Let this matter be listed
On 6, your lordship. I'm so sorry, 6 Thursday.
on 6th of August. The interim order shall continue till next day.
Much obliged.
May it please your lordship. Lordship, on consensus prayer, lordship, we'd like to mention item number 13, lordship. From the hearing is supplementary, lordship.
Yes.
Let this matter be come up on 17, lordship.
Heard
For the
Mr.
appellant, I have no objection.
Heard Mr. Imti Wapal, learned counsel for the respondent
1 to 4, lordship.
1 to 4, who prays for an adjournment.
Consensus, lordship. With the
Mr.
parties.
Foseko Forte, the learned counsel for the appellant, does not oppose to the said prayer. The prayer is allowed. Let this matter be listed on
17, Lordship.
17th August.
Lordship.
Highly obliged, Lordship.
English Lordship, Your Lordship, I beg to mention item number 9. Your Lordship, I have already filed my amended petition on 22/7/2026. However, Your Lordship, 6. However, I was subsequently informed by the petitioners that some of the respondent, that is respondent number 9 and 9 to 12, have been changed. So I seek some time to verify the correct particulars of the respondent and thereafter file an IA.
Heard, Miss, what's your name?
Sigma.
Item name. Item number 9.
Item number 6, Your Lordship.
Learned counsel for the petitioner who submits that what you have, who submits that though an amended
Amended petition.
petition has been filed, however, the incumbent of to the post of
Your Lordship, they are making a submission that respondent number 9 to 12 in the present amended petition is either transferred or retired, and therefore they wanted to.
stop. She, however, submits that the respondent number 9 to 12 have been either transferred, have been transferred, and she requires to verify the field. And as such, some time is prayed for. The prayer is not opposed to by London government.
Senior government.
Senior, I forgot your name.
Enangami, Your Lordship.
Anangami, the London Senior Government Council. Hence, the prayer is allowed. Let this matter be listed after
4 weeks.
after 4 weeks. Yes.
May I please, my Lord?
Lordship,
Lordship, I beg to mention item 9. Item 9. Lordship, I have instruction to appear for respondent number 1 in this contempt petition, Your Lordship. I'm entering my appearance for the first time. So if 3 weeks can kindly be granted to receive the necessary instruction, my Lord.
Heard Mr. Foseco Forte, Learned Counsel for the petitioner. Also heard Mr. N. Angami, the Learned Senior Government Counsel, who submits that he has instruction to appear on behalf of respondent number 1,
1 month.
and he needs some time to take necessary instruction and to file his affidavit in opposition.
Lordship.
The prayer is allowed. Let this matter be listed after 3 weeks.
I'm deeply obliged, my Lord.
Obliged, my Lord.
For admission, item number 2.
What is this?
May I please, my lord? My lord, this is an application under section 5 of the Indian Limitation Act, my
Limitation.
lordship.
How much delay is there?
My lord, delay of 289 days, my lord. I have explained it at para 6 of my application, my lord. Internal page number 5, my lord. Paragraph 6 starts.
You are insurance company.
My lord.
Yes,
My lord, may I read?
yes.
That the applicant having its registered and head office in so-and-so, Goregaon, Mumbai, and regional and divisional offices in several places of India, including a regional office at Gauhati, Assam. Applicant did not have any empanel counsel for the region of Twensang during the year 2023, my lord. However, after having received the notices from the learned tribunal, Twensang, the regional office at Gauhati tried to contact to empanel an advocate for Twensang region, but by the time the applicant could engage a counsel for the said region, the MSc case proceeded ex parte and was fixed for judgment. The regional office at Gauhati, on receipt of the judgment dated 25/7/2024 from its penal counsel based at Twensang on 2/5/2025, forwarded the same to its head office at Mumbai on 5/5/2025 for approval in preferring the McAppeal. The applicant's head office, after approving the case for
It
preferring,
was an ex parte judgment.
my lord,
Ex parte judgment.
my lord,
What is the date of the judgment?
the date of judgment, my lord, 25/7/2024, my lord. And the year when the MSc case was instituted in the year 2023, at that point of time, there was no empanel counsel for the region of Twensang for the applicant company, my lord. And by the time the applicant company could engage a counsel, my lord, the case proceeded ex parte. My lord, the applicant's head office, after approving the case for preferring an appeal, intimated the same to its regional office at Guwahati on 26/5/2025. The officials of the company's regional office at Guwahati contacted the counsel based at Dimapur through an email on the last week of June 2025, assigning him the above said MSc case for filing an appeal. The counsel based at Dimapur received the hard copies of the MSc case number so-and-so only on 1/7/2025. The counsel, after having received the claim folder, gone through the impugned judgment and discussed with the senior manager legal claims, the legal points involved therein to prefer an appeal. The applicant's penal counsel could prepare the McAppeal and connected interlocutory applications and forwarded the same to the applicant's regional office at Guwahati on 17/7/2025 for necessary vetting and signatures. The instant appeal was finally filed on 8/8/2025. The period of appeal being 90 days from the date of judgment dated 25/7/2024, it expired on 25/10/2024. Thus, there has been a delay of 289 days in filing the instant McAppeal, and the delay has been caused due to the reason stated above and not due to willful negligence or default on the part of the applicant company. As such, the delay in filing the appeal may be condoned, my lord. My lord, however, this honorable court also directed the applicant company to file an additional affidavit in briefly discussing the days of delay. So I have filed my additional affidavit also. Your lordship may kindly find it on record, my lord. It was by order dated 14/8/2025, my lord.
Yes.
My lord. I so-and-so, aged about so-and-so, resident of so-and-so, do hereby solemnly declare and affirm as under that the appellant insurance company preferred the above referred interlocutory application in McAppeal number 16 of 2025 against the judgment and award dated 25/7/2024 passed by learned member MSc Twensang in MSc case number 38 of 2022, which is pending for hearing and disposal before this Honorable High Court. That in
But
filing
you
the-
received the notice from the tribunal
My lord,
in the MAC case.
My
In
lord.
the MSc case, you
My lord.
have received the notice.
my lord,
You could not appear only because you don't have any
I
panel.
could not have any counsel empanel over there, my lord. And by the time the counsel was engaged, the case proceeded ex parte, my lord. I have received the notice.
You should have engaged a counsel.
My lord, as your lordships aware that there are many regulations which the company has to follow to engage a counsel. But-
What regulation?
My lord, the primary condition is that one should have 5 to 7 years of experience on that. And
You have to relax those conditions if in a given place you don't have lawyers. You might have engaged private lawyers also.
my lord, there was the company was trying to impanel a council, my lord, but Twensang is a remote place, and
So there is no counsel in.
council is there, but no, I mean the council, they are not coming forward to get impanel with the company. That was the practical difficulty we have faced.
Why?
My lord,
You were willing to engage a counsel,
my
but
lord.
counsel were not ready.
Yes.
Is that your submission?
No, that was not my submission, but that was the instruction I have received, my lord. And by the time the company could engage a counsel, it proceeded ex parte, my lord. There was no willful intention to,
Okay, it proceeded ex parte.
my lord.
Then after the ex parte judgment was passed, why it took so much time for preferring the appeal?
Yes, my lord. That I have explained it in my affidavit, my lord. My lord, the date of judgment was the judgment was passed on 25/7/2024, my lord. And from August to September, my lord, the regional office Gauhati made repeated efforts to locate and impanel an advocate in Twensang. However, owing to the remoteness of the district, limited number of practicing advocates and communication difficulties, no suitable counsel could be finalized.
What do you mean by suitable counsel?
My lord, the length of practice, my lord. That is
As per your company's rules,
my lord.
you could have engaged any counsel, available counsel.
My lord, yes, I do agree with your lordship, my lord. But then the private counsel outside Nagaland or outside this remote place, they do not come forward to.
Why outside Nagaland? You could have engaged any counsel from Queensland.
That is what, my lord. Nobody is coming forward to get engaged with the company. There are many other talks also, my lord.
Okay.
My lord. This delay caused this caused initial delay in obtaining the certified copy of the judgment, my lord. My lord, October 2024, the next page. By the time internal efforts were underway, the 90-day statutory period lapsed on 25/10/2024. At this stage, the regional office was still awaiting confirmation of a local council who could liaise with the tribunal and collect the certified copy of the judgment and order. November 2024 to April 2025, the situation was further compounded as Twensang is a remotely located hill district with poor road connectivity, intermittent internet services, and frequent postal delays. Consequently, communication between the regional office at Gauhati and Twensang-based legal representatives remained slow, and it was only after a persistent follow-ups that the certified copy of the award could finally be procured. On 2/5/2025, the regional office finally received the certified copy of the award from a Twensang-based council. Only by then, May 2025, my lord, the council could be engaged by the company, my lord. On 5/5/2025, regional office immediately forwarded the copy to the head office Mumbai for legal opinion and sanction to file an appeal. 26/5/2025, after an internal scrutiny by the legal department and higher management at Mumbai, approval was granted to file the appeal. The decision was promptly conveyed to the Gauhati regional office. June 2025. Regional office attempted to engage a council at Dimapur to prefer the appeal before the Honorable High Court. The final assignment and empanelment was confirmed only by last week of June 2025. 1/7/2025, the Dimapur-based council received the hard copy of the case records, pleadings, and claim folder. The council undertook a detailed study of the award, consulted with the senior manager legal claims of the applicant, and drafted the appeal and interlocutory applications. The draft of the appeal memo and connected interlocutory applications were sent to the regional office Gauhati on 17/7/2025 for vetting and execution. The regional office diligently completed the process of vetting, obtaining signatures and authorized signatories, and collecting the requisite supporting documents along with the affidavit verifications. However, these steps inevitably consumed additional time due to the layered official hierarchy and unavoidable postal delays, which were beyond the control of the applicant and not attributable to any
Why
negligence.
it was not within your control? It is your company's hierarchy only.
My lord, yes, but the unavoidable postal delays, the delay occurred in Twensang while empanelling the council, my
Okay, that is okay.
lordship. The McAppeal, the next page, my lord. The McAppeal, along with the connected interlocutory applications, was thereafter filed on 8/8/2025 before this Honorable High Court. The statutory period of limitation being 90 days from the date of judgment, it expired on 25/10/2024. The instant appeal has been filed after a delay of 289 days. That is the explanation, my lord.
Yes, Mr. Sharma.
May it please your lordship. Lordship, in my para 5 of my affidavit, in relevant page number 5, lordship, I have given a breakdown of delay, calculation of breakdown of delay, lordship. Actually, lordship, there has been a total delay of 379 days, lordship. From the date of judgment till filing of the appeal on 8/8/25. There has been a total delay 379 days, lordship. And the appellant paid for condonation of 289 days. And 90 days remain uncounted, lordship. There is no explanation whatsoever against 90 days, lordship. Lordship, the main ground of the petitioner appellant is that there is no panel advocate at Twensang, hence they are unable to represent themselves. It is absolutely false, lordship. In Twensang, there is a numbers of advocates who has even completed their more than 10-15 years practice in professional line. And their submission is that there is no much senior advocate, hence they are unable to engage them at a council. Assuming that if they think that councils for the Twensangs are not competent to defend them, they can defend him also from Dimapur or from elsewhere from India. There is no bar for the company. Lordship, in para 6 of my deposition in affidavit, in A, part A, lordship, subpara A, alleged that petitioner appellant did not have empanel counsel at Twensang during the year 2023. The petitioner insurer in para 6, page number 6 of the petition admitted that notice from the tribunal duly received. However, when such notice was received purposely and deliberately, it not mentioned so as to enable the petitioner insurer to get right on the period of limitation, lordship. The motor accident claims compensation claim was filed on 17/11/22, which being registered as MSC case number 38 of 22. The learned tribunal issued notice to the petitioner insurer, which duly served. Due to failure of the petitioner to appear before the tribunal, the learned member by its order dated 24/3/23 proceed ex parte against the petitioner, and in completion of proceeding passed the judgment and award dated 25/7/24, lordship. The deponent submits that claim petition filed on 17/11/22 till the date of judgment and award dated 25/7/24, that is total 615 days. The petitioner insurer have not even get time to engage a counsel to defend their case because of their lethargy, inaction, and dereliction of official duties, or not even made any inquiry in the whole period to know about the claim filed against the petitioner company, lordship. That is a total negligence of the insurance company. Till filing of the claim, lordship, till disposal, there has been a total 615 days. Within 615 days, the petitioner have no time to engage any counsel to defend their case, lordship. This is clear negligence, lordship. Lordship. In B, as alleged, from 25/7/24 till 17/7/25, almost a year, concerned file was moving in between councils, head office, and regional office level. Our apex court in Ketna of cases held that mere movement of file between office or the procedural delay within a corporate or governmental setup cannot constitute sufficient case. The Honorable Supreme Court and this Honorable High Court are repeatedly held that internal administrative inefficiencies or delay due to bureaucratic functioning does not constitute good ground for condonation of delay, Lordship. Lordship, in my affidavit in para 9 also, I have raised an objection. The deponent submits that, para 9, Lordship, the petition filed for condonation of delay and the appeal both are not maintainable as the petitioner have not seek remedy first by filing a petition under Order 9, Rule 13 CPC.
No, that is the option available. They may go for setting aside ex parte,
Yes, Lordship.
or they may appeal against the order also.
But when there is a totally ex parte order, at least they have to first revoke the
No,
remedy under
that is their choice.
the Lordship. That is their choice, Lordship. But negligence is clear. There is a clear negligence.
Yes, negligence.
Because the 615 days, they will not get time to engage any counsel to defend their case. Only after passing of judgment and award, they come forward for filing the appeal. What they have done for the whole period, nothing, Lordship. An allegation is that in Tuensang there is no competent advocate. That is false, Lordship. That is totally false. Company is such a big company, they can engage any one counsel, any competent counsel, even from anywhere from India, Lordship. This is my submission. It is not a fit case to condone delay. Now, otherwise also their prayer is only for 289 days, whereas 90 days delay remain unexplained, Lordship.
Still,
That's my submission, Lordship.
let me reply.
My lord, with regard to the days of delay, my lord, as explained in the Limitation Act also, Section 5. Section 5 says there should be sufficient cause shown to condone the delay, and the word sufficient cause should be given a liberal approach rather than iron cast technique, my lord. The Honorable Supreme Court also in Catena of Decisions has held that the court, while pursuing with a delay condonation petition, should look into the matter with a liberal approach, my lord. And my lord, for that I would like to.
The question is, Lordship, what about the 90 days, which is uncounted totally?
My lord,
Whereas
90
Supreme
days,
Court
90 days
in the
is
full
my
bench
90
decision,
days,
Lordship.
90 days is my limited time.
No, Lordship, that cannot be. That cannot be,
That cannot
Lordship.
be counted. That is why
No.
379 days, sir has counted 379 days from the date of judgment till the date of filing. Deducting 90 days, it is 289 days, my lord.
Entire delay to be explained, Lordship. In the Sitaram Ramasaran
My delay will be
versus
counted.
NM
My delay will be
Nagrasan
counted, my lord, from the
reported in
91st day, not
1960,
the
it is a
90
full
days.
bench decision, Lordship. It is a full bench decision where it is stated that the entire delay to be explained, not partially.
My delay will be
Maybe
counted from
that
the
90 days
91st.
may be a benefit for them. That has to be counted. That has to be
How that
explained,
can be
Lordship.
counted?
No,
How that can be counted? That cannot be
No,
counted at
Lordship.
all.
delay starts
From the 91st day.
from the 91st day.
But
That cannot
here
be counted.
there is a some Supreme Court decision, Lordship. On the basis of this principle,
What
your
is-
Lordship also pleased to decide the cases.
What it says.
Yes, Lordship. In Sitaram Ramachandra versus NM Nagrasana, reported in 1960, one SCR, wherein Honorable Supreme Court held that
You have to exclude the
there
prescribed period.
there is not shown that 90 days to be excluded, entire period to be explained. In para 19 of the judgment, Lordship, this is a It is a full bench decision, Lordship. The relevant para is 19, Lordship. The last page, Lordship.
Yes,
Bear it, Lordship.
yes.
The proviso with which we are concerned has prescribed the limitation of 6 months from the institution of the application itself. And so the principle laid down in language case 1921 1 KB 655 can have no application to the question which we have to decide indeed. The present proviso is in substance similar to the provision in section 5 of the Limitation Act. Mr. Falke has fairly consulted that there is consensus of judicial opinion on the question of the construction of section 5. It cannot be disputed that in dealing with the question of condonation of delay under section 5 of the Limitation Act, the party has to satisfy the court that he had sufficient cause for not preferring the appeal or making the application within the prescribed time. And this has always been understood to mean that the explanation has to cover the whole period of delay, Lordship. Whole period to be explained, Lordship.
Whole period means
From
when the delay starts.
yes, from when the delay starts.
Delay starts from the 91st day. The limitation is till 90 days, there will be no delay.
Yes, Lordship. I'd like to refer one more decision. Ikbar Ahmed versus Sip Devi, reported in 2018 SC online, wherein Honorable Allahabad High Court referred to judgment of the Apex Court in Manoj Debraj Shah versus Municipal Corporation of Barhin, reported in 2012 5 SCC 157. What need to be emphasized is that even though a liberal and justice-oriented approach is required to be adopted in the exercise of power under Section 5 of the Limitation Act and other similar statutes, the court can neither become oblivious of the fact that the successful litigant has acquired certain right on the basis of the judgment under challenge, and a lot of time is consumed at various stages of litigation. Apart from the cost, what color of expression sufficient cause would get in the factual matrix of a given case would largely depend on bona fide nature of the explanation. If the court finds that there has been no negligence on the part of the applicant and the cause shown for the delay does not lack bona fide, then it may condone the delay. If, on the other hand, the explanation given by the applicant is found to be concocted or he is thoroughly negligent in prosecuting the case, then it would be a legitimate exercise of discretion not to condone delay, Lordship. I'd like to refer another decision of your Lordship. Assam State and others versus Gitarani Kolita, reported in 2017 2 GLT 1190, wherein our High Court has referred a judgment of the Honorable Apex Court, Office of the Chief Postmaster General versus Living Media India Limited, reported in AIR 2012 SC 1506, wherein it was held that claim on account of impersonal machinery or inherited bureaucratic methodology of making several notes cannot be accepted in view of modern technologies being used as available, and that the law of limitation undoubtedly binds beyond including the government. Relying on the aforesaid ruling, aforesaid government, Lordship. So on the basis of this, by following this all decisions, your lordship was pleased to pass the one judgment in the National Insurance Company Limited versus Nandakanai Pegu. The judgment dated 11/5/23, wherein your lordship was pleased to dismiss the cases with a reason shown, lordship.
Return that. Return that.
This is your lordship's order.
After the judgment, return, keep it. Heard, Mr. V.
Lordship.
Devnath, the learned counsel for the applicant. Also heard Mr. B. N. Sharma, the learned counsel for opposite party / claimants. This application under Section 5 of the Limitation Act 1963 has been filed by the applicant, namely Reliance General Insurance Company Limited, praying for condonation of delay of 289 days in preferring the connected appeal, whereby it has impugned the ex parte judgment and award dated 25/7/2024, passed by the Motor Accident Claims Tribunal, Queensland, in MAC case number
38 of 22.
38 of 2022, whereby the applicant insurance company was directed to pay a compensation amount of rupees 22,09,250 along with an interest at the rate of 9% per annum from the date of filing of the claim petition till realization. The Mr. V. Devnath, the learned counsel for the applicant insurance company, has submitted that though the applicant insurance company had received the notice issued in MAC case number 38/2022. However, it could not appear before the Motor Accident Claims Tribunal or engage a counsel to defend it, as the Motor Accident Claims Tribunal was situated in a remote district of Tuensang, and as such, the MAC case number 38/2022 proceeded ex parte, and on 25/7/2024, the ex parte judgment was passed. Stop. He submits that the applicant insurance company does not have we're not having any panel lawyer in Tuensang owing to remoteness of the region where the Motor Accident Claims Tribunal was situated. He submits that after the delivery of the impugned judgment and award by the Motor Accident Claims Tribunal, the regional office of the applicant insurance company may defer to empanel, get a lawyer empaneled with the applicant insurance company. However, owing to remoteness of the Tuensang district and limited numbers of practicing advocates in the said district, no suitable counsel could be finalized by the applicant insurance company. Stop. He further submits that it is only on 2/5/2025, the regional office, at Gauhati of the applicant's insurance company could obtain the certified copy of the impugned judgment and award from a council based at Tuensang. He further submits that on 5/5/2025, the regional office immediately forwarded the certified copy to its head office at Mumbai for legal opinion and sanction for filing an appeal against the impugned judgment. The head office granted approval for filing an appeal only on 26/5/2025. And it is only in the month of June 2025, the empanelment of lawyers for the applicant insurance company was confirmed. He further He further submits that in between 1/7/2025 to 17/7/2025, the drafts of memo of appeal as well as connected interlocutory applications were finalized and sent to Regional Office Gauhati for vetting and stop. The Regional Office Gauhati completed the process of vetting and other formalities by 8/8/2025. Now, in between 17/7/2025 to 8/8/2025. He submits that the time between 17/7/2025 to 8/8/2025 was consumed due to layered official hierarchy of the applicant's insurance company and unavoidable postal delays, which were beyond the control of the applicant. And ultimately, on 8/8/2025, the appeal was finally filed before this court. And in the process, a delay of 200 and how much delay?
289.
289 days where 289 days occurred, full stop. He submits that the delay occasioned in the instant case in filing the connected appeal was beyond the control of the applicant insurance company, and same has been explained by giving sufficient reasons in the instant interlocutory application. As such, he prays for condoning the delay. He further submits that while considering an application for condonation of delay under Section 5 of the Limitation Act, the court should take a liberal and justice-oriented approach. In support of his submission, he has cited following rulings. Number 1, Inder Singh versus State of Madhya Pradesh, reported in 2025 Live Law within bracket SC 339. Number 2, Collector Land Acquisition Anantnag versus Musammat Katiji and others, reported in 1987 2 SCC
107.
107. Stop, next para. On the other hand, Mr. B. N. Sharma, the learned counsel for the opposite party / claimants, has vehemently opposed the prayer for condonation of delay in preferring the connected appeal by the applicant. He submits that though the applicant has stated that the delay of 289 days have been occasioned in filing the appeal. However, in fact, the applicant has in fact, in this case, the delay is of 379 days, and the applicant has not explained the delay of 90 days in any manner. He further submits that the period of limitation of 90 days during which the appeal ought to have been referred has also to be explained by the applicant as to why the appeal could not be preferred during this period. In support of his submission, he has cited a ruling of the apex court in the case of Sitaram versus Nagarashana, Nagarashana, reported in 1960, within bracket 1960, 1 SCR 875. Stop. Learned counsel for the claimant/opposite party has further submitted that the plea of the applicant that no suitable counsel was available in Tuensang district cannot be believed, as there are sufficient number of competent and experienced counsel in Tuensang district. He submits that the applicant, in spite of receiving the notice from the Motor Accident Claims Tribunal, failed to appear before the trial court, as a result of which the inquiry proceeded ex parte against the applicant insurance company. He further submits that the applicant has deliberately suppressed the fact as to when it had received the notice from the applicant from the Motor Accident Claims Tribunal in MAC case number
38 of 22.
38 of 2022. Thereby willfully concealing from this court the date and time when it came to know about the pendency of the MAC case number 38 of 22. Stop. Next para. The learned counsel for the claimant/applicant further submits that the claim petition in the MAC case number 38/22 was filed by the claimant on 17/11/22, and the ex parte judgment was passed on 25/7/2022. Thereby, the duration of the pendency of MAC case number 38/2022 before the Motor Accident Claims Tribunal Tuensang was for about 615 days. And during this period, the applicant insurance company took no steps to engage a counsel either to defend their cause before the motor accident tribunal or to inquire about the fate of the motor accident claims case number 38/2022, which he submits reflects the negligence on the part of the applicant insurance company. He further submits that even after getting the certified copy of the impugned judgment and award on
25/7/24.
25. No. When they received. Two 5/2025, the applicant's insurance company took more than 3 months' time to file appeal before this court due to the internal bureaucratic procedures required for getting approval for filing the connected appeal. He submits that the insurance company, the applicant insurance company was well aware about the period of limitation of 90 days for preferring the connected appeal. In spite of the same, due to its own bureaucratic lethargy in taking the approval for filing appeal, the appeal has been filed belatedly, which may not be regarded as sufficient cause within the meaning of Section 5 of the Limitation Act 1963. He submits that the grounds stated in the instant interlocutory application by the applicant insurance company may not be regarded as audible, may not be regarded as sufficient cause, even if a liberal approach is taken. As such, he prays for dismissing the instant interlocutory application. In support of his submission, he has cited a ruling of this court in the case of National Insurance Company Limited versus Nanda Kanai Pegu and two and others, within bracket, judgment dated 11/5/2023 in IA Civil number 3/2021. I have considered the submissions made by learned counsel for both sides and have gone through the materials available on record. Stop. I have also gone through the rulings cited by learned counsel for both sides in support of their respective submissions. Stop. Though this court does not have any second opinion regarding the settled legal proposition that while considering an application for condonation of delay, a justice-oriented as well as liberal approach shall have to be taken by the courts, however, while doing so, it has to consider the reasons stated by the applicant justifying the delay in filing the connected appeal. Stop. If the reasons so stated are found to be sufficient, are found to be within inverted comma sufficient cause within the meaning of Section 5 of the Limitation Act, delay may be condoned. However, if same is not found so, the delay may not be condoned. In the instant case, it appears that the petitioners, the applicant insurance company, had admitted that it has received the notice from the Motor Accident Claims Tribunal Tuensang in MAC case number 38/2022. However, it opted not to defend its cause before the said Motor Accident Claims Tribunal in the aforementioned inquiry, owing to unavailability of a panel lawyer at Tuensang. Stop. Be that as it may, though it choose to let the MAC case proceed ex parte against itself, However, when the impugned judgment was passed in the MAC case number 38/2022 on 25/7/2024, it took no steps for filing any application for setting aside the ex parte decree under Order 9, Rule 13 of the Code of Civil Procedure. Rather, it preferred to file an appeal against the said. Stop. Though the option to file an appeal against ex parte judgment and award was available before the applicant insurance company, it ought to have preferred the appeal within the prescribed period of limitation of 90 days. However, the appeal was filed only after a lapse of 289 days beyond the prescribed period of limitation.
Lordship.
289.
Lordship.
Stop. The plea of the learned counsel for the applicant that the applicant insurance company did not have any panel lawyer to defend it, panel lawyer at Twinsang for filing appeal before the High Court is not convincing, as though the MAC case number 38/2022 was pending before the Motor Accident Claims Tribunal, Twinsang, the appeal had to be preferred before this court, which is situated at Kohima. The plea that it could not obtain certified copy and other documents from the Motor Accident Claims Tribunal within time is also not acceptable, as same could have been done by any counsel which might have been engaged by the litigant insurance company. This court is therefore unable to unable to persuade itself that for the reason of not having panel lawyer at Twinsang, the insurance company could not file appeal before this court at Kohima within the prescribed period of limitation. Further, even after the time taken by the insurance company in getting the administrative approval for preferring the appeal against the impugned judgment, though has been justified, though has been justified by the applicant insurance company, does not inspire the confidence of this court as stop. stop. As the period of limitation of 90 days is well known to a period of limitation of 90 days in preferring an appeal against an order passed in a motor accident claims case is well known to insurance companies. It has to devise its internal procedures for obtaining approval for filing such appeals so as to conform with the statutory provisions providing for the prescribed period of limitation. The merely taking plea that the official hierarchy of the applicant insurance company and the time taken in getting the administrative approval for filing an appeal took time which is beyond the prescribed period of limitation may not be accepted when the case involved is a case of compensating a victim of motor vehicular accident. Stop. As such, next para. In view of the discussions made in the foregoing paragraphs and reasons stated herein before, this court is of considered opinion that the applicant insurance company has failed to justify that it was prevented by sufficient cause in preferring the connected appeal beyond the prescribed period of limitation. As such, this interlocutory application is dismissed. In the connected appeal, MSC appeal, heard Mr. V. Devnath, learned counsel for the appellant, also heard Mr. B. N. Sharma, the learned counsel for the respondent claimant. In view of the orders passed in the IA C number 152/2025, whereby the prayer for condonation of delay in preferring the instant appeal, delay of 289 days in preferring the instant appeal has been rejected, this appeal is found to be barred by limitation and accordingly dismissed. The appellant insurance company is directed to pay the awarded amount to the respondent/claimant within a period of 6 weeks from the date of this order.
My lord, if I submit something, my lord.
Yes.
My lord, yes, of course, this is a case of compensation and the claimants, they have lost one of the living person. My lord, but this is also a case wherein the owner of the vehicle did not pay the premium. And as per the judgment of Inder Chand.
Now you have to go to Supreme Court only.
Stop like that.
Yes, next item.
Yes, Lord.
For orders, item number 5.
This item number
5, Lordship.
5,
Yes, authors.
arbitration petition. Yes. None has appeared for the petitioner on call. Let this matter be listed after 2 weeks on a date to be fixed by registry.
For orders, item number 7.
May I please, Your Lordship. Lordship, here we file our amended cost title, Your Lordship. We're completed response number 7.
What is this matter?
Lordship. Contempt petition, Your Lordship.
Okay, yes. Who is appearing for the respondent?
Lordship. Lordship, here I'm appearing for the chief engineer, Lordship. I have filed my affidavit. I have already filed my.
And Mr. Chen,
Lordship, I am representing the respondent number 1. That is the Commissioner Secretary of Works and Housing. I'm yet to file my affidavit, compliance affidavit. So, Lordship, may please to allow me some time.
Lordship, this is a 2025 last year contempt petition, Your Lordship. Order was passed on the.
what was the order?
Your Lordship would come to page number.
What was the direction?
Direction was to regularize the service of the petitioner, Your Lordship. Before his retirement, Your Lordship. That was July. Now I've already retired. It's more than 1 year.
We have retired.
Yes, Your Lordship. I retired last year, July, Your Lordship. And the direction was to regularize my matter, my service before my retirement.
The state has not preferred any appeal.
No, Your Lordship, they have not preferred any appeal, Your Lordship, till then.
Then you have to comply with it.
Lordship, on one occasion, Your Lordship, 07/04/2026, Your Lordship. And that instance, if Your Lordship would come to that order, the respondent, they have
Order dated
07/04/2026.
7/4.
Lordship, here, if you. Lordship, submission was given that the process for regularization of the petitioner's service is been taken up and under near completion, Your Lordship.
Yes, what is your stand in your affidavit, Mr. Zimomi?
Lordship, as far as I'm for respondent number 6, Lordship, chief engineer, Lordship. The matter has been forwarded to the higher authority, Lordship.
Lordship, it has been forwarded, Your Lordship. However, the other respondents, they're yet to give any instruction or any affidavit to the till date, Your Lordship.
Mr. Im Chen,
Yes, Lordship.
you are for respondent number 1.
That is the
Who is
Commissioner
for
Secretary.
3?
That is the Commissioner Secretary.
Lordship, respondent number 3, Your Lordship, have been replaced by respondent number 7, Your Lordship. That is the engineer-in-chief MPWT, Your Lordship.
So
Lordship.
who has to take decision? You have to take decision.
Lordship, respondent number 3, that is the Engineer-in-Chief of the MBWD Department. He is represented by my colleague, Sabong La. She's due to some personal difficulties, she could not be here today.
But you have
Now, what the Chief Engineer Works and Housing has done has to go to the Engineer-in-Chief. And from there, it has to come to me. That is the Commissioner Secretary. And from there, it has to go to the PNR Department. And from there, it has to go to the Cabinet, State Cabinet, Finance and the State Cabinet. So the procedure is.
This is known to everyone, but you have to take a decision.
Yes. The procedure is like that, the procedure. So allow us some time.
Your Lordship, if
So
I
it's
may,
my-
Your Lordship. Your Lordship, here respondent number 7, Your Lordship, engineer-in-chief, Your Lordship. if you would appreciate the fact that he has been appearing from the second appearance on the second date, Your Lordship. But till that, they have not filed any affidavit, Your Lordship. No instruction have been given, Your Lordship. They have been appearing from September 2025, Your Lordship.
You
They were the
file,
first one to
file your
appear.
affidavit.
Yes.
Allow us some time, Your
Lordship,
Lordship.
if short time be given, Your Lordship, and
Okay. Heard Mr. M. Solo,
3 weeks time, Your Lordship.
the learned counsel for the petitioner. Also heard Mr. V. Zimumi, the learned government counsel appearing for respondent number 6. And Mr. Moa Imchen, the learned senior government counsel appearing for respondent number 1, who submits that some time may be granted to the respondent number 1 to file an affidavit in opposition.
short time be given, Your Lordship, since
The
I
prayer
have
is
already
allowed.
retired.
Suggested date 7th of September.
Lordship, if 7th of September, final chance be given to them, Your Lordship. Else, I've been retired, Your Lordship. I'm already 62 years old, Your Lordship, and I have no source of income as well.
Lordship, as I say, procedure is lengthy.
Your Lordship,
Legalization.
regarding the procedure, I have no objection, but however, Your Lordship, it's been more than 1 year, Your Lordship, and the direction was to regularize my service before my retirement, Your Lordship. Specific direction has been given, Your Lordship.
At least you file your affidavit.
Yes.
It is clarified here that no further chance would be granted to respondent number 1 for filing affidavit in opposition.
Lordship, as well as the other respondents, Your Lordship. The other respondents, 2, 5, 6, they are yet to file the affidavit, Your Lordship.
No,
The
as
other-
regards them, we are not, they are not before us today.
Lordship. Your
Let
Lordship, they have
me-
given their appearance, Your Lordship, as well.
List accordingly on 7th.
Item number 8,
May it please Your Lordship. I am for the state here, state respondent 1, 2, and 3. Now, I am in receipt of the instructions. So I'll be filing my affidavit, so allow me 2 weeks time. Rabbit respondent is also there.
Heard
So far as state is concerned.
Miss Mika H.I., the learned counsel for the petitioner. Also heard Mr. Moa Imchen,
Lordship, I'm for respondent number 4 and 5.
the learned senior government counsel, who seeks some time for filing affidavit in opposition in this case. The prayer is not opposed. Also, Miss
Vikono on behalf of James Newman.
Miss Vikono. Vikono Kiso. Vikono Kiso. Appearing on behalf of respondent number
4 and 5.
4 and 5. The prayer is allowed. Let this matter be listed after 3 weeks.
Lordship, there is an interim, Lordship.
The interim order shall continue till next day.
Much obliged, Lordship.
from the supplementary cost list for orders, item number 11.
Maybe, Your Lordship. Lordship, here the state government is taking up his matter in court number 2. So let this matter be taken up after the listed item.
After some time,
Yes, Lordship.
okay.
For hearing, item number 12.
Yes. Give this back to Mr. Devnath and Mr. Sharma. Give him.
Nagaland Court, Volume 2. Twenty-six.
Yes, Mr. Lonja.
Lordship, yesterday I was reading the provision of the 1965 Act, the Acquisition Act. So we stopped there, my lord. Let me continue from there, madam.
Yesterday also, when you started submission, rain started.
Lordship, I don't know whether it's a good sign or not. But it's-
For that, you have to wait. Okay, yes, please.
Lordship, may I kindly come to, let me start from section 9 onwards again, my lord. Yes. Lordship, may I read, my lord? Section 9. Speedy acquisition of land in certain cases. Notwithstanding anything contained herein before, if in the opinion of the state government or the collector, it is necessary or expedient to acquire speedily any land for public works, including any of the objects mentioned in subsection 1 of section 3, the state government or the collector by order in writing acquire the land stating the area and the boundaries thereof. Subsection 2, my lord. The collector shall cause the order passed under subsection 1 to be served in such manner as may be prescribed. My lord, the rule 11 of the rules has already prescribed the manner in which it has to be served on the owner of the land and also the tenant or the occupant in case where it is not in occupation of the land, and also a notice of the same effect stating that claims to compensation for all interest in the land may be made to him within such time as may be prescribed. Provided when the persons to be served is not readily traceable or the ownership of the land is in dispute, the collector shall cause the above order and notice to be published in such manner as may be prescribed. So, Lordship, we are in the village. We were in the village in the year 1974. It is not a caution that we are not traceable. And they have also not said that we have served it. They have only said that we have published it in the official gazette, which is not the manner in which it should be served. Lordship, even today, I don't know, my lord, maybe the office of the additional AG also does not get Nagaland Gazette every month. Villagers in 1974, my lord, from where will they have access to official gazette? Then, my lord, may kindly come to section 10.
Yes.
Yes, then when the order of acquisition is served, so when it is served to the landowner's mother or published under subsection 2 of section 9, the land vests absolutely in the state government, free from all encumbrances on the date the order is so served or published. So with the serving, my lord, only then the land get vested. Otherwise, the land will not vest in the state. Only when the order under subsection 9(1) is served in terms of subsection 2, the land will vest. Now, my lord, the collector, subsection 2 of 10, the collector may at any time after the land becomes so vested proceed to take possession thereof. So they can proceed to take possession only after vesting, my lord, unless after serving the notice. Otherwise, my lord, it cannot. So any occupation or any possession is illegal, man. On such vesting, the order passed under subsection 1 of section 9 shall be published in the official gazette in the manner prescribed. Only then the publication comes, my lord, in the official gazette. There are certain steps to be taken before that. Now, Lordship,
So therefore, my lord, in terms of the law laid down by the Honorable Supreme Court, if this is not done, the entire accusation, purported accusation, my lord, is null and void. It's known as in the eye of the law. It's no accusation at all. Now, Lordship may kindly come to the manner in which compensation has to be paid. Yes. Lordship may kindly come to section 11. Compensation. Subject to provision of subsection 2, whenever any land is acquired under subsection 1 or section 9, there shall be paid compensation, the amount of which shall be determined by the collector. In determining the amount of compensation of the collector shall take into consideration the market value of the land for a period of 5 years preceding the date of publication of the notice under subsection 1 of section 6, where the land is acquired under that section, and where the land is acquired under section 9 from the date of passing the order under subsection 1 of the said section. And the amount of compensation payable shall be on the basis of average market value so arrived at. So, my lord, the market value has to be assessed. There has to be an assessment made, my lord, by the deputy collector, the DC. Then, my lord, first proviso, provided that where any building is acquired under subsection 1, the compensation shall be payable at market value of the building on the date of publication of the notice under subsection 1 thereof. So this is not relevant, my lord. There was nothing standing there. Provided further, except for the plants and crops, provided further, my lord, this is important again, provided further that in addition to the market value of the land or building, as above provided, the collector shall in every case award as some 15% of the market value in consideration of the compulsory nature of acquisition. So, my lord, 15% above the market value, that has to be paid. The solution of 15% is mandatory, my lord. My lord, subsection 2. When the compensation has been determined under subsection 1, the collector shall make an award in accordance with the principles set out in section 11 of the Land Acquisition Act 1894. So therefore, my lord, when the compensation is determined in terms of section 11, then, my lord, the manner in which it is to be paid, the 1894 Act of section 11 of 1894 Act, the principles laid down therein has to be followed again. Section 11 of the 1894 Act. Lordship may kindly come to where any land is, Lordship, this is relating to subsection 3 is relating to requisition. So this is not relevant in a present case, my lord. So my lord may kindly come to subsection 12, section 12 now, reference. The collector shall in every case where any person aggrieved by an award, my lord may kindly note the word, any person aggrieved by an award made under subsection 2 of section 11. The award is made in terms of section 11, my lord, and a person who is aggrieved by that award may make an application requiring the matter to be referred to that there is a civil court. So, my lord, if a person is aggrieved by an award assessed in terms of section 11, then he has to go to the collector, and the collector will refer the matter to the civil court. Here, my lord, I'm saying there's no award, there's no accusation. B, my lord, where there is a disagreement with regards to the compensation payable under subsection 3 of section 11 of the on the application of the person entitled to compensation, requiring the matter to be referred to the court, refer the matter to the decision of the court. Now, my lord, subsection 2. Subject to the provision of this act, provision of the Land Acquisition Act 1894 shall mudadis apply in respect of any reference made to the court. So, my lord. So this, and there, my lord, but furthermore, my lord, section 13, when the amount of any compensation payable under this act is not paid or deposited within 30 days from the date of the award, the collector shall pay the amount award interest thereon at the rate of 6% per annum from the date of award until it shall have been paid, so paid or deposited. So if there's a delay, means 30 days, my lord. So there's a penal interest also. Now, Lordship may kindly come to section 17. Section 17, my lord. Save as otherwise provided, save as otherwise expressly provided in this act, no decision or order made in exercise of power conferred by or under this act shall be called in question in any court. My lord, before that, kindly come to the page 21, my lord. Definition. Kindly come to page 21, section 2, my lord.
Yes.
Court B, my lord. Court means a principal civil court of original jurisdiction and includes the court of any additional deputy commissioner, assistant to deputy commissioner, whom the state government may appoint by name or by virtue of his office to perform concurrently with any such civil court, all or any of the function of the court under this act within any specified local limits. So court has been defined to be the civil court. Now, my lord, coming back to section 17 again, if I may. So it says, my lord, save as otherwise expressly provided in this act, no decision or order made in exercise of power conferred by or under this act shall be called in question in any court. So, lordship, if the authority had exercised the powers under this act, if the land was acquired exercising these powers, following the provisions of the Acquisition Act, then yes, my lord, then it is barred. But if this has not been followed, as held by the Supreme Court also, my lord, that this procedure, whatever procedure they purportedly adopted, cannot be called an acquisition proceeding under the Act. Lordship. Now, Lordship may kindly come to power to make rules, section 20. The state government may make rules for carrying out the purpose of this act. 2, in particular, and without prejudice to the generality of the foregoing powers, such rules may provide for any or following matters, namely, the manner of service of orders on the owner or occupier of the land referred to in subsection 2(3). B is important, my lord. The manner of service of notice and orders on the person referred in subsection 2 of section 7 and in subsection 2 of section 9, my lord, respectively. So therefore, a rule has been framed, my lord. I placed it the other day. There's a manner in which the notice has to be served is prescribed. It has to be followed. Publication in the official gazette will not be. In both the applications for rejection of the claim, it is only said that it was published in the official gazette. Now, lordship, may kindly take the Land Acquisition Act 1894 because section 11 is applicable.
Land acquisition.
It will. 1894. Land Acquisition Act. But it will be there. the Land Acquisition Act 1895. This will be possible soon. Remember. Excuse me, just it is. Yeah, Tuna. Section 11, my lord. Yeah. Section 11, no. Lordship, may I read section 11? On the days of fixed or any other day to which the inquiry has been adjourned, the collector shall proceed to inquire into the objections, if any, which any person interested has stated pursuant to a notice given under section 9 to the measurement made under section 8 and into the value of the land at the date of publication of notification under section 4 subsection 1 and into the respective interest of the person claiming compensation and shall make an award under his hand of the true area of the land, the compensation which in his opinion should be allowed for the land. 3. Apportionment of the said compensation among all the persons known or believed to be interested in the land of whom or whose claims he has information whether or not they have respectively appeared before him, provided that no award shall be made by the collector under this subsection without the previous approval of the appropriate government or such officer as the appropriate government may authorize in this behalf. Provided further that it shall be competent for the appropriate government to direct the collector to make such award without such proposal in such cases as the appropriate government may specify in this behalf. 2 is important, my lord. Notwithstanding anything contained in subsection 1, if at any stage of the proceeding, the collector is satisfied that all persons interested in the land so appeared before him have agreed in writing on the matter to be included in the award of the collector, in the form prescribed, my lord, in the form prescribed by the rules made by the appropriate government, he may, without making any further inquiry, make an award according to the terms of such agreement. The determination of the compensation for land under subsection 2 shall not in any way affect the determination of compensation in respect of other land in the same locality or elsewhere in accordance with the other provisions of the Act. 4, my lord, subsection 4, notwithstanding anything contained in the Registration Act, no agreement made under subsection 2 shall be liable to be registration under the Act. Now, my lord, Lordship, 11A. The collector shall make an award under section 11 within a period of 2 years from the date of the publication of the declaration, and if no award is made within that period, the entire proceeding for the acquisition of the land shall lapse, provided that in case where the declaration of the land has been published before the commencement of the Land Acquisition Act 1894, the award shall be made within a period of 2 years from such commencement. Explanation, my lord, in computing the period of 2 years referred in this section, the period during which any action or proceeding has been taken in person of the said declaration is stayed by an order of the court shall be excluded. My lord, 12 also is important because this is how the award has to be made. 12. Such award shall be filed in the collector's office, my lord. They must have a copy of in the collector's office and shall accept, as herein provided, be final and conclusive evidence. It must be there and it will become an evidence as between the collector and the person interested, whether they have respectively appeared before the collector or not, or of the true area and the value of the land and the appointment of the apportionment of the compensation among the person interested. 2, my lord, the collector shall give immediate notice of his award to such of the person interested as are not present personally or by representative when the award is made. So, my lord, 12 is very important. The award should be there in the this office, and the award must be communicated to the person that is the landowners. This has not been done. This has never been done. And even, my lord, lordship has seen yesterday, So many documents saying that this is office that the award is not there. From now recently they produced something out of nowhere. Earlier they have said even their internal communication says there's nothing. No document.
Now in their IAs, which have been filed,
Yes,
which
Lordship, I'll read that.
they have produced the section 9 notification,
Yes, now. They
not
produced,
award,
not before that.
but not the award.
Not the award. And my lord, award must also contain the details. It is given what are the details that is required to be mentioned in the award that is also provided, my lord. 23, no? 23. 23, my lord, section 23. No? Huh? Man, 12 only man. 12 only on that. I don't know. I wrote it somewhere. Can I go in? So, Lordship, Lordship, how the compensation, of course, section 11 deals with how the compensation has to be done, our local lab. So, my lord, and section 31 also deals with payment here, my lord, of 1894 Act. So, my lord, the details of the particulars has to be mentioned.
Now, what is your submission?
No, my lord. Okay. Lordship, so therefore, my submission is the act, the law, the statute, my lord, dealing with acquisition has prescribed the manner in which acquisitions has to be made. And if there's slight deviation, it is that acquisition is bad. It's known as in the eye of the law. Here, my lord, the starting point itself is bad. Notice not given. We're not giving notice to the person, the landowners. That,
But then it could be challenged only in writ proceeding.
that is why, my lord, that is why initially I have submitted that Article 3, of course, in 1960s, my lord, right to property was a fundamental right. And in 1978, it was amended and it made a constitutional right, Article 300A. Now, therefore, my lord, a person can be deprived of his property only by due process of law. Now, my lord, if the due process of, whether the due process of law has been followed or not, by rejecting the claim, I have not got the opportunity to show that this process, the due process of law has not been followed. So therefore, my respectful submission was, my lord, that the suit may not be maintainable only on one ground, that is barred by section 17. And if that is the case, my lord, then I have the option of approaching this court under 226. And the writ court will decide whether my property has been deprived without following due process of law. But now when the honorable court below has held that I have no cause of action and so many other things, then that hampers my case before the writ court also. That is my case. That is the reason. So I'm showing, since they are saying accusation, no, it is not an accusation at all. This is not an accusation, my lord. This is not, because it's not in terms of the act. And if it's not in terms of the act, it's none in the eye of law. It's not an accusation at all. That is my case. But, my lord, if lordship comes to a finding that this is an accusation, then, lordship, I must get an opportunity to approach in accordance with law before the appropriate forum. Not shut up my case at the threshold like it has been done by the honorable court below. Now, lordship, here section 54 is there because the respondents are also relying on section 54. Lordship may kindly come to section 54. Lordship, section 54.
Yes.
Lordship. Subject to the provisions of the Code of Civil Procedure 1908, applicable to appeals from original decrees, and notwithstanding anything to the contrary in any enactment for the time being in force, an appeal shall only lie in proceedings under this Act to the High Court from an award. So from an award, if the award, an appeal will lie, the civil court, it will be referred to, my lord, reference to the civil court, an appeal will lie only to the High Court. Or from any part of the award of the court and from any degree of the High Court pass on such appeal aforesaid, an appeal shall lie to the Supreme Court subject to the provisions contained in subsection 110 of the CPC and in order 45. So therefore, my lord, if there's an award and I'm aggrieved by the award, I go to the collector to refer the matter for reference. And after that, my lord, in terms of 54, is applicable only then. Will only be applicable appeal against that order pass by the civil court. Now, my lord, section 54, therefore, is not applicable in this case, present case, because there is no award. In terms of law, then, my lord, 2013 Act, section 63 of the 2013 Act has been also relied upon by the respondents.
13 Act is not applicable.
Yes, no, it's now
Now-
division by
now
size
there
is
is
not
a-
applicable, so I will leave that, my lord. Only thing is, my lord, in my prayer before in the plaint, in the prayer number 2, accusation, compensation in terms of the 2013 Act.
That you have submitted that if the case this
Yes,
is
my lord,
allowed
at
you.
that point of time, I'll
No,
give the decision also. But lordship, whatever it is, quoting a wrong provision it's not a ground to reject my case, because if the law is there, the relevant law will be applicable, my lord.
Okay.
Okay, ma'am. Now, therefore, my lord. Now, Kishi, you are looking, just a minute. Lordship was yesterday a query, my lord.
Yes.
Lordship now. So therefore, my lord, court, the plaint was rejected because, lordship, I may have to read the objection file, it's a short application, 2 applications. May I just go through that? 400, 411. 411, my lord. Hmm? 411, my lord, relevant page starts from 411, my lord. This is the application filed by Director General of Police, the Chief Engineer, and the Commandant for rejection of my plaint. Lordship, the relevant portion starts from 416. Lordship, may I kindly come to 417. The relevant portions only I'll be reading, my lord. Lordship, therefore, that paragraph 2, that before going into the grounds for seeking rejection of the plaint, the applicants beg to narrate in brief the background of the case. The suit in land in connected civil suit number has been acquired by the state, my lord. So categorical statement has been duly acquired by the state of Nagaland as per the procedure by initiating appropriate proceeding as provided under the Nagaland Requisition Acquisition Act. So categorical statement that is an acquisition under section 9 and 11 compensation has been paid. So the lordship, this provisions has been, yes.
Yes.
Yeah. Lordship, as the provisions of section 9 has been quoted, we can skip this, my lord. We can skip kindly come to page 420, my lord. Paragraph B. The suit land in question was acquired by the state of Nagaland for establishment of the 2nd Navy Battalion, as it was found necessary and expedient to acquire speedily the suit land. The Deputy Commissioner Mok Chung has issued notice as prescribed under subsection 9 of the said Act of 1985 by notification dated 18/4/1974 inviting objection to such acquisition within the period as stipulated therein. The said notification was also published in Nagaland Gazette on 15/5/1974. Lordship, no notice was given to the landowners. It is stated that though the respondent plaintiffs were aware of the fact that the suit has been acquired by initiating proceedings under the Acquisition Act, they are completely silent about the acquisition proceedings in the claim. We are not aware of any acquisition proceedings, my lord. C. That there was no objection from any quarters that the suit land was acquired after assessing the compensation as provided for under section 11 of the Act of 1985. The compensation so assessed is also already been paid and duly acknowledged by landowners. If it was done in terms of section 11, my lord, there is a procedure prescribed. They have not included that. Nowhere. It's just that bold, bare statements. Nothing to substantiate this. In fact, my lord, D. In fact, in order to ensure smooth acquisition process, the state government has approached respective landowners before the initiation of the acquisition proceeding in respect of the suit land as regards the acquisition and compensation. Therefore, even prior to the notification dated 18/4/1974, it was agreed upon within the parties to pay compensation at the rate of 2,000 per acre on the request of the landowners, to which the plaintiff number 8, the only living signatory to the letter dated 25/9/1973, was a party thereto. Thereafter amended of section 11 of the said Act 1965, compensation were duly paid for the acquired suit land in question. My lord, plaintiff number 8 has categorically denied that is not his signature. He has never agreed to any compensation, land compensation. In fact, they had decided not to sell the land. Signature doesn't tally at all. Their perusal will show me. Then, my lord, E, the connected civil suit number 1 of 22, the respondent plaintiffs are completely silent as regards the said acquisition process and receipt of compensation as has been filed the same inter alia praying for, my lord. So, my lord, then kindly come to page 423. My lord. Grounds. As stated, the suit land in question, has been acquired as per the procedure prescribed under Act of 1985. It is pertinent to mention herein that land acquisition 1894, Act 1894, is also applicable in the present case. Section 54 of the Act provides us under. We have read that, my lord, Section 54. It's only when an award has been duly passed in accordance with the provision of the Act, then this will be attracted. Therefore, my lord, filing of the connected civil suit before this honorable court is barred by section 54 of the Act, read with section 9 of the Code of Civil Procedure. As such, the connected civil suit number such and such is liable to be dismissed, being barred by law. My lord, section 70, if it is an acquisition, then section 17 will be attracted. Then, my lord, B, furthermore, section 63. So this also of the 2013 Act is not applicable, my lord. Then we can skip this, my lord. Then lordship may kindly come to 425 page. No cause of action. The respondent plaintiff do not have any cause of action as they do not challenge the acquisition proceeding initiated by issuing the notification that is such and such. Lordship, no need to challenge. I'm saying there's no acquisition at all. That's just enough, my lord. In the connected civil suit, the respondent have cautioned, and thus notification was never furnished to us. Respondents have cautioned only the validity, legality of the sale date. In this connection, it is stated that section 11 of the 65 only provides for payment of reasonable compensation. Therefore, a valid acquisition, what needs to be examined is whether reasonable compensation has been paid, provided under section 11 of the Act, as per the record, reasonable compensation has already been paid respective landowners. Thus, question of validity and legality of sale does not arise. They themselves say it is not a sale, it's acquisition, my lord. And if it's an acquisition, the provision has to be followed. Compensation also has to be assessed and paid in accordance with the Act, and also award given in accordance with the Act. Award passed. C, even otherwise, by filing the connected civil suit, respondent plaintiffs are only questioning the validity and legality of sale deed without questioning, challenging the acquisition process initiated with issues of the notification dated 18/4/1974. In other words, the respondents are challenging only consequential orders without challenging the basic order. Honorable Supreme Court in such and such has held that challenging a consequential order without challenging the basic order is not permissible. Therefore, as per the settled principle laid down by the Honorable Apex Court, the connected civil suit number such, challenging the constitutional order without challenging the basic order is not maintainable and liable to be dismissed. Lordship, we have been saying questioning the entire acquisition, not just the sale deed. Then barred by limitation, my lord. 3, Roman 3A. That by questioning the validity and legality of the sale deed in connected civil suit, the respondent plaintiff are indirectly challenging the acquisition proceeding, which was initiated in publication of notification dated 18/4/1974. What the respondent's plaintiff cannot do directly is being done indirectly. The respondent plaintiff at this belated stage, after a lapse of 45 years, cannot challenge the validity, legality of acquisition proceeding. Therefore, connected number such and such is liable to dismiss by lordship. And if an acquisition has not taken place, not 45 years, my lord, about more than 100 years, Supreme Court has allowed. In such and such case, reported in such and such, the Honorable Apex Court has held that when an aggrieved person without adequate reason approaches the court at his own pleasure, the court could be under legal obligation to scrutinize whether the lease at the belated stage should be made entertained or not. Is a further held that delay comes in the way of equity. My lord, here in this case, when it is a question of land acquisition, delay will not come in the way of equity. That is absolutely misconception, my lord. We have Supreme Court clearly says so, man. And my lord, when I say, my lord, illegal occupation, that itself is a cause of action. That whether it's an illegal occupation or not, that can only be ascertained not by objections raised. It has to be tried, my lord. Evidence is required. They have to prove these documents, and that it has been done in accordance with law. This is the reason why the civil court, the parties went to the civil court to prove that acquisition has not taken place. Sale has not taken place. That's that they had to establish because they were disputing it by furnishing all these documents. So this has not taken place. That is one of the reasons why civil court was approached, my lord. Because in a recourt, those disputed questions cannot be adjudicated. Estoppel, my lord. It is also stated that having acquired the suit land as per prescribed procedure under section 9 and 11 of the Act, the respondents are stopped from denying acquisition process. Lordship, I can always challenge it. I'm saying the acquisition has not taken place at all. So, my lord, this were the grounds raised. So, Lordship, again, similarly, it's also important to see, my lord, the other application page 483, my lord.
There are also similar grounds where
similar grounds, little different. Lot of stress has been made on Limitation Act and the CPC, my lord, here. Lordship, 483. This was filed by the page 483. Lordship has found it, my lord.
yes.
Lordship, this was filed by the state, represented by the Chief Secretary, Commissioner Secretary, Nagaland, Home Commissioner, and the Deputy Commissioner. So the revenue authorities, basically. The other one was by the police. So, Lordship, may kindly come to page 487.
Yes.
Lordship, paragraph 2. The applicant defendant defendants, back to narrate the brief background of the suit land. Following the General Administration Department appointment A branch, Government of Nagaland, letter number such dated 22nd April 64, which was issued in an order stating that Government of Nagaland is pleased to accord sanction to the raising of 2 armed police battalion Nagaland with effect from 1st April 1964. An amount of rupees 10 lakhs at the rate of 2,000 per acre for payment of compensation for 500 acre was sanctioned by letter number 7. Lordship, this is very important. In 1964, amount is already sanctioned that it will be 2,000 per acre. No, Lordship, that is not what the Acquisition Act says. 64. Look. Then, my lord. Subsequently, the office, next page, my lord. Subsequently, the office of the defendant number 5 issued a notification dated 18 April 1974, notifying that the land measuring such and such is being purchased. It's being purchased, my lord, by the project engineer. So this notification clearly says, as we have read it yesterday, my lord, that it's being purchased, not acquired. Then by the police project engineer for construction of second NAP headquarter at allegation from the landowner of Longkong village, and the said notification was published in the Nagaland Gazette on 15/5/1974. It does not say that this was served on the landowners. Publication in the official gazette. Therefore, should there be any claims and objection, a 30 days period was given. Having fulfilled due procedure, the government acquired the suit land by paying compensation amount for the land to all the respective landowners. It was determined in 1964. Land, and then he's saying it's being purchased. Give it. We have already settled 2,000 per acre. Now, my lord, paragraph 3. The applicant defendants beg to submit the following objection with regards to maintainability of the present suit. The suit is not maintainable in law as well as in fact. Respondent has no right, title, interest over the suit land, therefore has no locus standi to file the present suit, hence the suit is liable to be rejected. Then Order 7, Rule 3 provides that wherein subject matter of the suit is immovable property, a plan shall contain a description of the property sufficient to identify it, and in case such property can be identified by boundaries or numbers in a record settlement or survey, the plan shall specify such boundaries or numbers. However, the schedule of the property of each of the respondent plaintiff is not mentioned in the plan. So, Lordship, this was a query which was put to me also yesterday. We have met the general boundary of the entire 28 plaintiffs, their land is as adjacent to each other. So, Lordship, if Order 7, Rule 3 is not compliant, the claim cannot be rejected under Rule 11 of Order 7, because what are the grounds on which it can be rejected is clearly mentioned. This is not one of the grounds. And Lordship, yes, there may be a difficulty in distributing the land once, assuming a degree is passed. But Lordship, that will be amongst the plaintiffs. And the land, my lord, have their traditional boundaries. In fact, names are given to the plots, to the fields. So, my lord, it will be a distribution amongst themselves. So there will not, and traditional boundaries in terms of customs and practices, that will be distributed. But that area, the general area, has been described. Boundary has been described. Then, my lord, Roman 3, the suit is barred by subsection 3, section 3 and 27, my lord, section 3 and 27. Lordship, may I pause here for, let me finish this, my lord. And of the Limitation Act, the suit was acquired by the government in the year 1974. Since then, it is under continuous possessions. Lordship, this is adverse possession. They're talking about adverse possession, my lord. The respondent plaintiff have not locus standi to file the suit. This implies the suit was instituted after a lapse of prescribed limitation period.
Limitation Act. Please give
Yes, my lord. Therefore, on the basis of Section 3 of the Limitation Act, this honorable court ought to have dismissed the plaint on the threshold itself. Lordship, Limitation Act becomes important.
Limitation Act.
Lordship, they have referred to Section 3, first and 27. Can we just read this, my lord? Section 3, my lord. May I read? Lordship.
Yes.
Lordship, Section 3, bar of limitation. Subject to the provision contained in Section 4 to 24, every suit instituted, appeal preferred, and application made after the prescribed period shall be dismissed, although limitation has not been set up as a defense. It can be dismissed even if it is not raised. For the purpose of this act, as a suit is instituted, in ordinary case, when the plaintiff is presented to the, so Lordship, can we skip this? So then, my lord, may kindly come to 27. 27. At the determination of the period hereby limited to any person for instituting a suit for possession of any property, his right to such property shall be extinguished. So therefore, my lord, the right gets extinguished. Now, my lord, may kindly come to Article 65. What is the period? Lordship, may kindly see. Lordship, may kindly see 4 first. For 64 first. Article 64. Possession for possession of immovable property based on previous possession and not on title when the plaintiff, while in possession of the property, has been dispossessed 12 years from the date of dispossession. So 12 years from the date of dispossession. Therefore, they are saying that, my lord, here they are taking a plea that they are not the owner. When they take this ground, they are saying that we have taken the land, we have occupied it.
No, 12 years, not from the date of disposition.
So from the date of dispossession,
No. 12 years from the date when the possession becomes adverse to the
Lordship, I'm reading 64.
64.
64.
Okay.
I'm reading, I'll go to 65 also, madam. Date of dispossession.
Correct.
So Lordship here. So they are saying basically, then Lordship may kindly come to 65. For possession of immovable property or any interest therein based on title, 12 years from the date of possession of the defendant, from when the possession of the defendant becomes adverse to the plaintiff. Now here, my lord, adverse possession. So that means they have occupied the land. They don't have title, they don't have any right, they have occupied the land, and everybody knows it, including the landowner. That possession of the defendant is hostile to my rights. From that day, 12 years will be counted. But so, adverse possession. Supreme Court says, my lord, adverse possession, the law of adverse possession. That plea is not, that defense is not available to a state. To a state. It is in when the state is the defendant. When it's the state is the
So is it your submission against state limitation under
Yes,
65 is not applicable?
ownership or right through hostile possession beyond the prescribed period, that is not available to them. Lordship, that Amin Lal, State of Haryana versus Amin Lal, which was decided in 2024. Lordship, yesterday I referred it. That is, Lordship, in my list of authorities, it is at serial number 9, serial number 8. It was also a suit, my lord. The state of Haryana was the defendant. It was a suit. And there a defense was taken that because of this limitation period, my lord, the suit is not maintainable. Supreme Court says, no, it is not available to them. The state. My lord, then, so they're referring to this Limitation Act to say that the suit is barred by law, barred by the law of limitation, which that's being a state, that defense is not available to them. Then Roman 4, my lord. There's no justification for such a belated challenge as it's beyond one's comprehension that affected party whose property rights were extinguished will wait for long to seek redressal. In such circumstances, there can be no escape from the inevitable conclusion that the person's suit is hit by delay and laches, which is not applicable when it is a matter of accusation, my lord. At the determination of period of hereby limited to any person for instituting a suit for possession of any property, his right to such property shall be extinguished as provided under section 27 of the limitation. There's a contradiction in their argument also, my lord. Accusation, then they again rely on the limitation. There's hostile possession. Right has been extinguished. Any right that I have because of my delay in approaching the court, my right has been extinguished. There's a contradiction in the stand. So, Lordship, these were the grounds taken for rejection of my claim, and Lordship, these grounds were accepted by the Honorable Court below. And my claim was rejected at a threshold, which is a very drastic step, my lord. The person does not get an opportunity to prove his case. At least I'm not saying whether I'll succeed or not is a different thing, my lord. I must have the opportunity. If it is a purchase, I must be given a chance to say, since I'm disputing in the plain that I've not sold the land, I must be given an opportunity to go and dispute the sale and purchase. and the purchase by the state. That opportunity I must guess, because that cause of action is clearly apparent from the plain itself. And if it's an accusation, my lord, then the civil court will be right in dismissing the suit, rejecting the plain on the ground that is barred by section 17, but it must stop there only. It cannot go further, my lord. And then I will have the option of coming before this honorable court through a writ proceedings, in a writ proceeding, where I can say that accusation has not taken place in terms of the act. Whether I succeed or not, that's a different thing, but that opportunity, my lord, village people, my lord, this is the only means of livelihood. Now the Supreme Court Lordship has seen, it's not just a constitutional right, this is a human right. And without this right, all rights, other rights are meaningless. Now, Lordship, I'll be concluding, my lord. So, my lord, cause of action is there. I'm saying I'm disputing the cell, I'm disputing the accusation. That itself is a cause of action. Whether I succeed or not, that's a different thing, my lord. Limitation Act, Lordship is the same Limitation Act. Supreme Court clearly says it's not applicable. When the state is a party, when the state is claiming the land, then, my lord, Lordship, again, if it comes to limitation, my lord, then in 2021, restraining order was passed. It's a big area. It is not that entire land they have constructed something. This is a lot of vacant lands. We were constructing road, my lord, road connectivity. That has been stopped. That is only in 2021. Show cause notice was issued only in 2022, my lord. Then, Lordship also has seen adverse possession will not be applicable in this case. Then, Lordship, if we read section order 7 rule 7 or order 7 rule 11, only two. There are grounds mentioned. Not mentioning the schedule is not a ground. Cause of action and barred by law, that is a ground. And I have not properly valued the property concern. Those are the grounds given. CPC. Order 7, my lord.
They are mainly pressing for order 7 rule 11 A and D.
A and D, yes, my lord. A and D. So A will not come because I have disclosed cause of action. D, my lord, if this applicable, that means it's an accusation. Therefore, D is applicable. It is barred by law, not by the law of limitation, my lord. Not by the law of limitation. Only hit by section 17. Because civil court may not have the jurisdiction, will not have the jurisdiction. If they have taken the proceedings, accusation prosecution, strictly in terms of the accusation laws, that also, man. It has to be, it can be said to be an accusation only if the procedure prescribed by has been followed, due process has been followed. Otherwise, it is not an accusation at all. Lordship. No.
Okay.
Lordship. Then, Lordship, just this one, recent case, no? Recent case, no? Yeah, my lord, this is a recent judgment. I've just written down the paragraphs where it says that serving it to the village council also will not do. Landowners has to be given to the landowners. NOC from the village council also will not do. The landowners has to be served the notice for accusation. And then, my lord, this is the case where it says that the Act of 2013 has not replaced the Act of 1965. The relevant paragraphs I've mentioned, my lord, I'll not bother your lordship by reading it right now. Okay. The Bashir's oral judgment. The Bashir's cousin will, I think.
Now conclude. You have
Yes, lordship, I'm just conclude.
at some point of time you have to conclude.
I'll conclude now, man. No need to refer. No need to refer. My lord, this is the case, but Justice Devashish Bora, we are saying where paragraph 15, my lord, Accusation Act of 2013 was applicable.
But
that
is not required. That has been overruled.
Overruled. No, but what I'm saying is that was delivered on in March.
No, but law has been now settled.
No, what I'm saying is when I made that prayer, That is the reason why. Because now it is settled, now it is gone. But at that point of time, this law was prevalent because I filed a suit on 22, my lord, second half of 22, when this judgment was there. That is the reason why 2013 has been mentioned as a prayer. But my lord, even if that is not applicable, doesn't mean that I'm not entitled to compensation, or I'm not compensation under the Local Act 1965. I'm entitled. No? Yes. Lordship, this is a judgment, my lord, where I was saying yesterday, this was delivered only in the month of October 19th, 2023 by Justice Rishikesh Roy and Justice Manoj Mishra. They disagreed. Justice Rishikesh Roy said that
But that also has been referred to a larger
larger
bench.
bench. So, Lordship, if your Lordship wants, I'm just writing down the thing. Just that I'm concluding, my lord. Just the little portion I've already. Justice Lordship, there, I'll just brief. The land, there was an original landowner, he has sold it to Mr. A. My lord, the notice was given, the notice was given, my lord. Notice was given to the person, the original owner, whose name was there in the revenue records. The purchaser's name was not there in the revenue records. So notice was given to the person whose name was there in the revenue records. Justice Rishikesh Roy has said that, no, you have not given to the actual owner. So therefore, acquisition has not taken place. Suit also is maintainable. Justice Manoj Mishra says that, no, how do we know who purchased the land? As long as it's being served to the person whose name is there in the revenue records, then that will suffice. That was the difference only. It's much. So, Lordship, my respectful submission is that wrongly dismissed, rejected, cause of action is there, limitation act will not apply. And if it's at all, if it's hit by section 17, then my lord, the honorable court below should not have made those observations regarding cause of action and limitation. And I should have the opportunity to approach this honorable court under Article 226, challenging the acquisition.
Okay.
Obliged, my lord. Thank you so much.
Yes, Mr. Tiba.
Maybe sorry for interruption, my lord. I beg to mention item number 11, my lord. Kindly list the matter on Monday, my lord.
Next Monday.
Yes, my lord.
Item number 11, Miss, you have mentioned.
Yes.
Okay, heard Mr. E. Tiba from the Government Council appearing for the respondent. Also heard Ms. speaking of case of landed counsel for the applicant. It is,
I'm appearing for respondent number 9.
your name is?
Team Hombini Izung on behalf of Joshua Shiki.
Right hand names. Then Government Council has prayed for listing this matter on 10th of August. The prayer is not opposed to by the counsel for the other side, hence same is allowed. Let this application be, let this case be listed on 10/8/2026.
Much obliged.
We'll start at 2
Lordship.
instead of,
Lordship.
we'll take at 2.
Obliged.
Yes.
May I please lordships? Lordship, I am appearing for response number 3, 6, and 7.
Who are they?
Lordship. Number 3 will be the DGP.
Okay, for the police authority.
Yes. Number 6, Chief Engineer, Police Engineering Project. And number 7 is the Commandant, Second NAP, Alijan.
Yes.
Lordship. And your lordship, as this appeal is directed against the order of rejection of plaint, I will confine myself to the plaint and the documents annexed in the plaint, which is part of the plaint, your lordship. Now, for that, I will have to take your lordship to the plaint, to the case of the plaintiff before the civil judge, not the civil judge. Page 31, may I take your lordship to page 31? I will just take your lordship to some relevant paragraph. And also I'll read only the relevant portion, not the entire paragraphs. Page 31, para 3, this is para 3 of the plaint.
Yes.
May I read out? That the plaintiffs are having common grievance and the cause of action against the same defendants, inasmuch as the defendants are in forceful occupation, this is relevant, of a vast land of Longkom village, as fully described in the schedule appended herein below, without making payment of land compensation to the plaintiff. Now, para 4. That the defendants herein are the state of Nagaland and its machineries, responsible officers of the state of Nagaland, who are interfering with the plaintiff's land and illegally enjoying the traditional village land without acquisition, and also even without exercising norms of land acquisition procedure as provided under the Land Acquisition Act, which issuance of notice pertaining to claims and objection, notification, etc. So also without making payments of due compensation as per provision of law. Para 11, your lordship. Page 35, para 11. Lordship has got it.
Yes.
That on the subsequent approaches during 1970s, the state government released damage cost of plantation for the area of Alijan sector of Longkom village on lump sum basis to some of the landowners, but till date the plaintiffs had not been compensated in any manner in respect of the land forcefully occupied by the armed personnel initially and thereafter by the Nagaland police, that is the defendant. Now, para 34, page 48.
Yes.
That the defendants have arbitrarily and illegally occupied the land of the plaintiffs and have been enjoying the land without making payment of land compensation, whereto the defendants are either to vacate the forceful possession of the plaintiff's land or to make compensation of the land under the occupation of the defendant, that is the defendant number 7, is the commandant, your lordship, of that NAP battalion, 2nd NAP, as per the provision of, this is the Act of 2013. Now, para 49. Page 49, para 37. This is on the cause of action.
Yes.
That the cause of action in the suit arose when the defendant had forcefully entered into the land of the plaintiff in the year 1960s. Thereafter, in 1969, when the Langkom villagers adopted a resolution not to sell the village land to any other party and to approach for plantation damage compensation. On the various occasions when the plaintiff and the predecessor have approached the defendant for payment of plantation damage compensation. On 4/12/2021, when the plaintiffs were obstructed by the defendant from undertaking development activities in the village land. On 22/2/2022, when RT application was filed before the PIO. On 15/3/2022, when PIO furnished. Now, Your Lordship, from 14/12/2021, they have given the dates on which the cause of action arose. Now, 1969, from 1969, after a gap of about 52 years, then the next date, 4/12/2021, that is shown as the date when the cause of action arose. Now, para 40, according to the plaintiff, this suit is within the period of limitation, that is their claim. And 51 is the prayer. Prayer 1 is degree declaring the right and interest of the plaintiff. Title is missing in the plaintiff's land and restoration of possession. And 2 is that compensation under the Act of 2013, which the appellants are not pressing, Your Lordship. So from the plaintiff, Your Lordship, the case of the appellant plaintiff is that the state respondent is in forceful occupation of the plaintiff's land without acquisition and without payment of compensation, except for damage compensation, crops, whatever. Therefore, they have approached the court below with a prayer to declare the right and interest of the plaintiff over the suit land and to restore his position, or in the alternative, to pay compensation under the Act of 2013, Your Lordship. Now, may I take Your Lordship to the documents annexed in the plaint, page 339. Page 339. Lordship has got it. Type copy is 340. Yes. Now, for your Lordship's convenience, your Lordship may also note on page 339 to 369 of the plaint. These are the proceedings under Section 11 of the Act of 1894, Acquisition Act. Page 369 to 339 to 369. These are the proceedings. Your Lordship may kindly come to page 340.
Yes.
Now, Your Lordship, case number blank is there. Proceeding under Section 11 of Act 1 of 9. It should be, it is typing mistake. It should be 1894. Lordship has got it?
Yes.
Proceeding under. Now, name of the project. This is land acquisition for construction of second NEP quarter at Alichan, Langkom village. This is the area, Your Lordship.
Yes.
Now, may I take Your Lordship to 344. These are some of the documents, their own documents, 344. This is the assessment of award under Section 11 of Act 1. Lordship has got it. Additional compensation, those everything is mentioned. And below, the name of the landowners are there.
Yes.
Now, what I would like to impress upon your lordship is that their own documents which they have annexed and which is part of the plaint, your lordship, speaks for itself that the proceeding in respect of the Sudan has been initiated under the Acquisition Act of 1894. That is my case, your lordship. Now, may I take your lordship to page 63? I will take your lordship to the relevant provision, page 63. Lordship has got it, page 63. Lordship has got it? Yes. Page 63, this is a type copy. This is a sale deed. Page 63 to page 248, your lordship may note down, these are the sale deed agreement. Page 63 to 248. This is also part of the plaint.
Yes.
May I read out? This deed of sale made on 22nd day of April 1974 between such and such, Akangmer Ao. Now, next third para, and whereas the vendor has agreed with the purchaser to the purchase of land at the price is given 18,240. Now, this deed witnesses as in persons of the said agreement and in consideration of the sum of rupees such and such 18,240 only now paid to the vendor by the purchaser the receipt of the sum the vendor acknowledges. May I take your lordship to the receipt, money receipt, page 299. Money receipt, your lordship, it runs from 252 to 338. Money receipt.
253.
To 338. So may I take your lordship to the money receipt in respect of this agreement, Akangman 299. And your lordship, though sale deed is disputed, your lordship, the agreement is disputed. The questioning the agreement in this that there's no signature, it has not been registered, your lordship. This agreement is not under challenge. Whereas the money receipt is admitted. Page 299.
But whether these sale deeds are registered sale deeds?
I will come to that. I will come to that, your lordship. Page 63, your lordship may read page number 63 with page 299. That is, page 63 is the agreement. Page 299 is the money receipt. $299.
Yes.
Yes. So your lordship, page 63 should be read with 299. Page 63 read with 299. So here the receipt, money receipts, Sri Akangman, this is the seller, the landowner, agreed to sell second NAP allegation. This is the land in question. My land length at 18,240, this is the amount. Second para. Now I hereby acknowledge receipt of the said sum of 18,240 as full price of land. This is not damage compensation or crop compensation, and all appertaining to the said land. Similarly, your lordship may May take page 67, another sale deed. Page 67.
Yes.
Page 67 is another sale deed. It should be read with money receipt 301, page 301.
Yes.
So in page 67, this agreement, the vendor is Chompong Nikan, page 67.
Yes.
Yes, second line, Chompong Nikan. The third paragraph, the price is 4,460, it is there. Now the money receipt is page 301.
Yes. Yes.
Now, similarly, Your Lordship, I'll take Your Lordship to another sale agreement, sale deed agreement, page 71. Page 71, money received is at page 303.
Similar.
Similar,
Okay.
Your Lordship. Say, for example, page 75, another sale deed, money received 305, similar, Your Lordship. Okay. Now, may I take Your Lordship to section 11? Okay. Act of 1965. There is a Nagaland Land Requisition and Acquisition Act, 1965, Your Lordship. Lordship has got it.
Yes.
I'll be referring to other provision of the Act, section 9, 10, and also the rules, split rule 11 and form F of rule this thing, 1968 in the course of my submission. But for the time being, section 11. Subsection 2.
Yes.
When the compensation has been determined under subsection 1, the collector shall make the award in accordance with the principle set out in section 11 of the Land Acquisition Act 1894. In other words, Your Lordship, section 11 of the Act of 1965 is to be read with section 11 of the Act of 1894. May I take Your Lordship to the Act of 1894, section 11?
Yes.
Subsection 2.
Yes.
May I read out?
Yes.
Subsection 2 starts with non-obstante clause, Your Lordship. Notwithstanding anything contained in subsection 1, if at any stage of the proceeding, the collector is satisfied that all the persons interested in the land who have appeared before him have agreed in writing, that means there is an agreement, on the matter to be included in the award of the collector in the form prescribed by the rules made by the appropriate government, he may, without making further inquiry, make an award according to the terms and conditions of the said agreement.
Okay.
My submission is that, Your Lordship, it was notified in the Gazette with the landowner, an agreement was executed, and based on the agreement as agreed upon between the parties, Your Lordship, in terms of Section 11(2) of the Act of 1894, Your Lordship, by following the procedure, the award has been made by the collector, Your Lordship. Agreement has been executed and compensation paid, Your Lordship. And accordingly, the land has been acquired as per the procedure, Your Lordship. Now, Your Lordship, since Your Lordship has put inquiry regarding the registration, Your Lordship, I thought I will submit it, but since we are already on the act.
Regarding award also, when they filed RTI applications, none of the authorities could provide any copy of any award.
No, Your Lordship.
Neither you.
Those issues will come, supposing during trial, evidence, whatever.
Okay.
But here, my objection is that under Order 711, here the land has been acquired as provided under the Acquisition Act, and by virtue of Section 17, Your Lordship, the jurisdiction of civil court is part.
Then whether the land was acquired or it was purchased.
Yes. Now, I will come to Your Lordship has seen the Gazette notification. That notification has been issued under Section 9 of the Nagaland Land
65
Acquisition Act 1965. So when notification issued under Section 9 of the Act of 1965, it is not for the purpose of purchase, Your Lordship. Just because having the word purchase is used, that will not change the character that the land has been acquired under Section 9 of the Act of 1965. That word purchase will not change the character. When that notification was issued under Section 9 of the Act of 1965.
And the sale deeds?
Your Lordship. Yes, sale deed, agreement, Your Lordship. That is in terms of, I am covered under this as provided under Section 11, subsection 2 of the Act of 1894.
So your submission is that land was not sold, but acquired at the rate agreed upon.
Yes, agreed upon as provided under Section 11, subsection 2 of the Act of 1894. And when it comes to payment of compensation, Your Lordship, as per the Act of 1965, Section 11 of the Act of 1894 applies.
No, but the documents which you have shown are the sale deeds.
Yes.
Not the award.
No, sale, that is the agreement. That is the agreement, Your Lordship. May I take your Lordship again to the sale deed, Your Lordship? Page 63. Section 63, Your Lordship, page 63. Now these deed witnesses as in persons of the said agreement. So an agreement has been arrived between the parties, Your Lordship. And this is what Section 11.
These are not sale deeds. These are not deeds of sale.
Title is given sale deed, but deed sale of this is an agreement.
Okay. And in person to this agreement.
And which is in consonance with Section 11, subsection 2 of the Act of 1894. May I take Your Lordship to again the subsection 2, 1894.
Okay. So after this agreement, suppose an agreement has been reached between the acquiring authority and the landowners.
Lordship.
Then the authority has to pass an award.
So in terms of the terms of this agreement, of such agreement. So
Yes.
this is what is it that to Your Lordship.
Okay, let us treat this to be an agreement. Then also there has to be some award.
But in my respectful submission, Section 11(2) does not say so.
It says,
No, Your Lordship.
you read again.
Here, Your Lordship, what is the award? That is the assessment, the amount of compensation to be made,
Yes.
Lordship. So in writing, if both the parties agree to it, Your Lordship, then it will, that award means the compensation. So in terms of the said, in terms of the said agreement, the compensation will be made, the award will be made. That is my understanding, Your Lordship. The award here must be construed as the amount of compensation. For example, under MAC cases at the tribunal, what is the award amount of? So what is the amount of award? What is the amount of compensation?
Section 11 of the Act of 1894 is
It-
also,
Subsection
also applicable.
is applicable as per section 11(2) of the Act of 1965, which I have read.
Now, section Act of 1894 requires a copy of award to be kept in the office of DC.
Now, Your Lordship. That will be okay, whether at the time of evidence, Your Lordship, the respondent will be able to produce it before the trial court while taking evidence, that will be a totally different after 50 years, 52 years.
Yes.
But those will be matter which will be this thing have to be decided by leading evidence, Your Lordship. But my case here is that since this is a case of acquisition, Your Lordship, now by virtue of section 17 of the Act, Your Lordship, the jurisdiction of the civil court is not.
Okay. Under section 17.
Yes, Your Lordship, of the Act of 1965. And my another submission, Your Lordship, after having executed an agreement and after having received compensation for the land, Your Lordship, the petitioner at this stage cannot question the procedure in which the acquisition was done. Whether at this stage, after having executed an agreement, and as per the agreement, after having received compensation, whether at this belated stage after 50 years, the petitioner can question the manner that procedure was not followed.
No, his plea is that though compensation was awarded, it was for them.
Yes, but then
though you have shown that they have written in the receipts
Yes.
that it includes.
and money received is not being denied. Sale deed, they're questioning the sale deed on the ground that there is no, it is not properly stamped, Your Lordship. And regarding the stamp, Your Lordship, Section 2, subsection 4 says of the Act of 1894, notwithstanding anything contained in the Registration Act, no agreement made under subsection 2 shall be liable to registration under the Act. Subsection 4, Your Lordship, of the Act of 1894.
Section 4 of
11, Section 11, Act of 1894. So registration is not necessary, Your Lordship.
agreement need not to be registered.
Just there has to be a written agreement between the parties. That's all. Lordship has got it, subsection 4.
4 I am not getting.
11(4) of 1894, Act of 1894.
1894.
Lordship. Because this assessment agreement, whatever is done as per the subsection 2, of 1894.
Yes.
Notwithstanding anything contained in the Registration Act 1908, no agreement made under subsection 2 shall be liable to registration under that act. But even otherwise, Your Lordship, I say that even if registration is required at this stage, belated stage after 50 years, Your Lordship, it is too late.
No, otherwise your submission is that these are not the deed of sale. These are agreement under 11(2).
This is agreement under.
This at 63, though it has been captioned as deed of sale,
But
but
if
in
it is,
fact, it is an agreement.
yes, if it is read as a whole, it is an agreement.
And the money paid is in accordance with
The agreement,
agreement
in terms with the agreement.
as per the section 11 of the Act.
Of 1894,
Okay.
or the compensation or the award
So this is a case of acquisition
purely.
and therefore 17 is applicable and it is barred by law.
Lordship.
So under 711D, there is a bar.
Lordship. Lordship has completed my submission.
Okay. And other observation made by the trial court,
On the cause of action.
cause of action and limitation.
Now, Your Lordship. Now. Here, Your Lordship, just make one submission. As I've said, I will confine myself to the plaint and also to the documents annexed in the plaint. But in my IA, a petition file under Order 7 Rule 11, Your Lordship, I have annexed that gazette notification, Your Lordship.
Yes.
But if your Lordship may see the order, the impugn order, that gazette notification, it is not the case that the Learned District Judge Mokyung has taken into consideration the gazette notification. But coming to gazette notification, Your Lordship, in fact, Your Lordship may just so this is some case laws, Your Lordship, which I'll be referring to in the course of my submission. On gazette notification, Your Lordship, this is the reported in 2017 1 GLT 475, writ petition 4274. This one, Your Lordship has got it. Para 16.
Yes.
So Section 81 of the Evidence Act 1872 says that the court shall presume the genuineness of the official gazette. In such and such, the Supreme Court explained that the object of publication is to merely give information to the public. It is an official document. It is published under the authority of the government. Court will take judicial notice, in the sense that no evidence is required to prove the same.
So while considering an application under Order 7 Rule 11, apart from what has been stated in plain, court can take judicial notice.
Court can take judicial notice, but then of course nothing in the judgment, Your Lordship. Court, the state may I take Your Lordship to the
Yes, court has in the impugn order
No.
it has not taken into consideration.
No, not it's totally silent. Just on the plaint and the documents next, Your Lordship. But even gazette notification, there is no illegality because court can take judicial notice of it once it is brought to the notice of the court, Your Lordship.
Okay.
Because it is a public document, Your Lordship. May I take your lordship to the impugn order, which is at page 517. Your lordship, in the IA, since my learned friend, he has taken your lordship to my IA, the objection, the grounds taken. I'm not bother your lordship by taking to my IA, your lordship. Because my learned friend he has taken your lordship to the ground, to my IA, lordship. Now, so may I take your lordship straight to the impugn judge order. 19/1/2024, which is at page 512. Relevant para from para 20, operative portion, page 519. Para 20. Lordship has got it? Page 519.
Yes.
Yes. Upon hearing the counsel, such and such, 21. That the averment made in the plaint and the annexures filed along with the plaint on the face discloses the acquisition of land in question has been acquired as per the procedure prescribed under it. So the learned district judge Mokshong, your lordship, while rejecting the plaint, has taken into consideration only the averment made in the plaints and the annexures filed along with the plaint, your lordship. And from the plaint itself, along with the documents, clearly established that the land in question has been acquired as per the procedure prescribed under the Act of 1965, read with the Act of 1894. Now, the Gazette notification, in my respectful submission, only supplements the facts about the land acquisition. Only supplements. And my ground will come Order 7, Rule 11A on cause of action, without challenging the acquisition process, your lordship. Proceeding. Appellant plaintiff does not have any cause of action, and therefore is not entitled to any relief. Because the cause of action is 1974 notification. May I take your lordship to the second authority, 2022-12, SCC 641. This is on rejection of plaint. I'll be referring to again this citation, your lordship, but for the time being, para 19. Here, lordship has got it.
Yes.
Para 19, the event has been quoted. 20 23.6 in italic, your lordship. Next page, 653. Lordship has got it. 23.6. Under Order 7, Rule 11, a duty is cast on the court to determine whether the plaintiff discloses a cause of action by scrutinizing the averment in the plaints, read in conjunction with the documents relied upon, or whether the suit is barred by law. These are two different aspects, your lordship.
No, the submission of the appellant was that it does mentions about the cause of action. When there was an forceful encroachment by the respondent authorities, it itself creates a cause of action.
It is not a forceful coup because the land has
No,
been,
that is his
that's
accusation.
his case, but my case is that the land has been acquired by issuing notification which is published in the Gazette. And unless that gazette notification, that notification which is published in the gazette is challenged, the appellant plaintiff does not have cause of action, because the cause of action starts from there, not from middle, not from the cell date. That is my case, Your Lordship. So cause of action, though supposing may have a cause of action, but whether it is barred by law, these are two different aspects.
Yes. And whether a person, the plaintiff is having cause of action is a different aspect, and whether he is entitled to relief is a different
Aspect. And whether it is barred by law, that is different aspect. And relief will come only if plaintiff has got.
Your submission is that unless he challenges the acquisition notification,
Yes.
he is not entitled to relief.
Yes.
But then whether it means that he has not mentioned any cause of action, what you make me understand this aspect.
Now, your
That Order 7 requires that plaint should contain a cause of action.
Lordship.
That he has a right, his right has been infringed,
Yes.
and that is the reason for which he has approached the court.
Yes.
So his submission is that in the plaint he stated that he has right over the land and land has been forcefully encroached.
Yes.
That is his cause of action.
That is his cause of action, but their own documents, the plaint speaks for itself that it has been acquired by initiating proceeding under the Acquisition Act. Their own documents. So,
Yes.
so where is that issue of encroachment?
No, one of his submission was if the acquisition is not as per law, that is non-est in the eye of law.
Then that should be challenged. That is the cause of action. Without challenging it, even administrative.
Without challenging it, he may not get relief.
In my respectful submission, no. That notification regarding acquisition.
Whether both things are same, not getting a relief and not mentioning cause of action in the plaint.
Relief issue will come only
Because
if relief will come.
Plaint may be rejected only if there is absence of cause of action.
Yes. Yes.
Now, whether he will get, ultimately he will get relief or not, that will be decided at a later stage. At the stage of rejection of plaint, is it the question before the court that whether the plaint discloses a cause of action or not, whether he is entitled to relief or not, that will be after the trial of the suit.
No, Your Lordship, again, may I take
You
your
clarify this aspect.
Yes. May I take Your Lordship again? Para 23.6. May I read again?
Yes.
Under Order 7, Rule 11, a duty is cast on the court to determine whether the plaintiff discloses a cause of action by scrutinizing the averment in the plaint. That is one. Read in conjunction with the documents relied upon, or whether the suit is barred by any law. So whether for reading of the plaint along with in conjunction with the documents relied upon, whether the plaintiff has a cause of action. That has to be examined, or whether the suit is barred by law, Your Lordship. In my respectful submission, Your Lordship, subject to Your Lordship's satisfaction, since the notification, gazette notification is not regarding acquisition of land is not being challenged, that is which is the main cause of action, because the petitioner is not entitled to any relief. Petitioner has no cause of action. And in fact, Your Lordship, next, I'll take Your Lordship to the next case, Your Lordship, 2010 1 SEC.
Yes.
756, para 22.
Yes.
Para 22. It is a settled legal proposition that challenge to consequential order without challenging the basic order, statutory provision on the basis of which the order has been passed cannot be entertained. Therefore, it is a legal obligation on the part of the party to challenge the basic order, and only if the same is found to be wrong, consequential order may be examined. Now, in this case, Your Lordship, my respectful submission, the basic order is the gazette notification, the acquisition proceedings. Now, without challenging the acquisition proceedings, Your Lordship, the petitioner cannot question the validity, legality of the agreement, sale agreement. That is my case.
Okay.
So in my respectful submission, there is no infirmity in the finding by the London District Judge Mukchung that the plaintiff does not have cause of action. That is under Order 7, Rule 11, Your Lordship. Now, on being barred by law, Your Lordship, that I'll just take one case law, Your Lordship.
And barred by limitation.
That is on barred by law, I'll take Your Lordship to that, then limitation next, Your Lordship. I'll just one authority, next 2027 SCC 366. Para 23. Okay, in fact, this has been relied upon. Page 376, Para 23, Your Lordship has got it. Yes. Para 23.1, this is rejection of claim. That is a provision, Order 7, Rule 11, Your Lordship. We can skip it. Para 23.2. The remedy under Order 7, Rule 11 is an independent and special remedy wherein the court is empowered to summarily dismiss a suit at a threshold without proceeding to record evidence and conducting a trial on the basis of the evidence adduced if it is satisfied that the action should be terminated on any ground contained in this provision. So it includes cause of action. Otherwise, cause of action, if it will be subject to evidence trial, Your Lordship, then having Para 7, Order 7, Rule 11A will be redundant. Now, 23.4. In Azhar Hussain versus Rajiv Gandhi, this court held that the whole purpose of conferment of power under this provision is to ensure that a litigation which is meaningless and bound to prove abortive should not be permitted to waste judicial time of the court in the following words. The whole purpose of conferment of such power is to ensure that a litigation which is meaningless and bound to prove abortive should not be permitted to occupy the time of the court and exercise the mind of the respondent. The sword of Damocles need to be kept hanging above his head unnecessarily without point of or purpose. Even in an ordinary civil litigation, the court readily exercises the power to reject a claim if it does not disclose any cause of action. So evidence trial does not arise, Your Lordship. 23.5. The power conferred on the court to terminate a civil action is, however, a drastic one, and the condition enumerated in Order 7, Rule 11 are required to be strictly adhered to. Now, the same paragraph, under Order 7, Rule 11, a duty is cast on the court to determine whether the plaintiff discloses a cause of action by scrutinizing the agreement in the plaintiff, read in conjunction with the documents relied upon, or whether the suit is barred by any law. Now, 23.13, page 379. Three 23.13, Your Lordship. If on a meaningful reading of the plaint, it is found that the suit is manifestly vexatious and without any merit. 23.13, page 379.
Yes,
Lordship has got it.
yes.
If on a meaningful reading of the plaint, it is found that the suit is manifestly vexatious and without any merit and does not disclose a right to sue, the court would be justified in exercising the power under Order 7, Rule 11 CPC. The power under Order 7, Rule 11 CPC may be exercised by the court at any stage of the suit, either before registering the plaint or after issuing summons to a defendant, or before conclusion of trial as held by this court in judgment such and such. The plea that once issues are framed, the matter must necessarily go to trial was repelled by stage. Now, last paragraph, 23.15. The provision of Order 7, Rule 11 is mandatory in nature, Your Lordship. It states that the plaintiff shall be rejected, the word shall is used, if any of the grounds specified in clause A to E are met out. If the court finds that the plaintiff does not disclose a cause of action, Lordship, or that the suit is barred by any law,
Yes.
Lordship, the court has no option but to reject the plaintiff. So in my respectful submission, Your Lordship, as the appellant plaintiff has not challenged the acquisition proceeding, Your Lordship, so that no cause of action, Your Lordship. Now, now may I take Now, may I take Your Lordship to the second case where I referred only to one subpara, Your Lordship, that is 2022-12, Rajendra Bajoria. I referred to only para.
Yes.
Para 19, 20. Lordship has got it?
Yes.
Para 19. We are in complete agreement with the finding of the High Court insofar as the reliance placed by Sri Sajan on the judgment of this court in Dahiban, which I relied, to which one of us was a member is concerned. In our view, the state judge, rather than supporting the case of the plaintiff, would support the case of the defendant, para such and such. So the underlying object of Order 7, Rule 11 is that if it ensues no cause of action disclosed or the suit is barred by limitation under 11D, the court will not permit the plaintiff to unnecessarily protect the proceeding in the suit. In such a case, it will be necessary to put an end to the sham litigation so that further judicial time is not less wasted. So same principle para 20 also, Your Lordship. On same principle on rejection plaintiff, Your Lordship. So in my respectful submission, Your Lordship, there is no illegality or infirmity in the order passed by the learned district judge.
On limitation?
On limitation, Your Lordship, barred by limitation, Your Lordship. Now, in this case, Your Lordship, the proceeding was initiated, sale deed was executed, money received, everything in the year 1974. I'm not on gazette notification. The sale deed, money received, everything was in the year 1974. Now, the appellant plaintiff cannot be allowed to question the validity and legality of the acquisition proceeding and the sale deed agreement, Your Lordship, after a lapse of 45 years. As been
one query from my side.
Lordship.
If the court agrees to your submission under Order 11 Rule, or Order 7 Rule 11D, that it is barred by law,
I'll leave it to you.
then whether,
I'll leave it to you, Lordship.
no, suppose this court accepts, or the trial court accepts, after accepting,
Whether
it can go into question of limitation.
That I leave it to your Lordship, but as I've said, Your Lordship,
Because question of limitation would come only if otherwise there is no bar.
Jurisdiction is there.
But when the trial court is barred by law to entertain, then whether it can delve on the question of limitation. Because question of limitation presupposes that the court has jurisdiction, but for the limitation, it cannot take up the matter.
No. Your Lordship, now cause of action, that Order 7, Rule 11A is different, Your Lordship, unless if court cannot reject a plain on the ground that there is no cause of action without issuing evidence, without trial, then the very purpose of having Order 7, Rule 11A will be defeated. So that is cause of action is different. Being barred by law will be law. In this case, Your Lordship, under the Acquisition Act, Section 17, civil court jurisdiction is barred. And Your Lordship, barred by law may be even barred by limitation, Your Lordship.
Law of limitation.
Lordship. So barred by law cannot be just only one. It can be both under the Limitation Act as well as under Section 17 of the Acquisition Act, 1965, Act of 1965, Your Lordship. That is my submission, Your Lordship. Now, on that, Your Lordship, I will just place some authority, Your Lordship, without going to the facts, Your Lordship. Yeah. One is, Your Lordship, Nardev Joshi. This is land acquisition and compensation, Your Lordship.
Yes.
This is by the Honorable High Court of Delhi, Your Lordship. Lordship has got it.
Yes.
I'll take Your Lordship to para 22 and 23, but this is by division bench. Para 22.
Yes.
The legal position regarding the approach to be aborted in cases challenging land acquisition proceeding is no more res integer. The division bench of this court in such and such had examined the question of delay and laches in challenging the land acquisition proceeding. While dismissing the petition on delay and laches, this honorable division bench has said here. There is no explanation as to why the petitioner slept over the matter for more than 2 decades before filing this petition. In this case, Your Lordship, after 4 decades, Your Lordship, nearly 50 years. The legal position regarding the approach to be adopted in case challenging the land acquisition proceeding has been settled by a long line of decision of Supreme Court and that of this court. The decision emphasized the need for the petitioner to act diligently and to approach the writ court in good time. Far from showing any diligence, the petitioner has been totally remiss in agitating the matter at the appropriate stage. He has allowed the proceeding to attend finally without raising a little finger against the same in such and such. The declaration under Section 6 was issued in the year 1966, whereas the writ petition was filed in the year 1972. The Supreme Court considered this delay to be sufficient to warrant dismissal of the writ petition on the ground of laches. The court held that if there was any defect in the notification under Section 4, issued as early as in the year 1959, and a declaration that under Section 6 was issued in 1966, there was no reason why the petitioner should have waited till the year 1972 to come to the court. It was not declared the court permissible for the petitioner to sit in the fence, allow the government to complete the acquisition proceeding on the basis of such and such. Now, 23. In another case, Pradeep Kumar and others in of India, the similar view was taken and the writ petition challenging the acquisition, which was filed after a delay of 10 years, was dismissed. Acquisition. Here in this case, even the acquisition process is not challenged, Your Lordship.
No, but
And
these pertains to writ petitions.
Writ petition, and here Your Lordship has rightly said. Now, the case of the appellant is that submission is that so far as the state is concerned, limitation does not apply, Your Lordship. Now, even in civil suit limitation act apply. In writ proceeding, no limitation, Your Lordship. But even then, the Honorable Appeals Court has come out with a doctrine of delay in legislation.
That is applicable to writ petition.
Yes.
But in civil suit,
So limitation comes because limitation is
Limitation comes under what provision?
Under the Limitation Act, because it
Limitation Act,
applies to all
which
suit.
specific provision?
Yes, limitation applies to suit.
No. My query is, though the trial court has observed in the impugn order that the suit is barred by limitation,
Lordship.
but it has not specifically mentioned that under Article 64 or 65 or
Whether
because it has to be barred under specific provision. Now 65 as per the learned counsel for
if
the
it is
appeal.
for position. If it is for position, then 65. Now, if the petitioner is challenging the sale deed, now cancellation of any instrument, whatever, that will be, I think, under Article 59, that is 3 years, Your Lordship. But my submission, Your Lordship, none mentioning of the specific provision, if it vitiates the finding of the learned trial court, I have nothing to say on that, Your Lordship, because it's not mentioned. But if that vitiates
Because
the
one of the submission of the appellant side was that 65 is not applicable against government. Because government cannot take the plea of adverse causes.
No, I'm not playing. I'm not. I'm not.
You are not claiming adverse cause. Therefore,
it's acquired.
Therefore, 65 does not come into.
Does not come.
Then under what provision it is barred?
If at all he has to challenge, he is questioning the sale deed, the validity and legality of sale deed. It is not signed. It is not registered. Your Lordship. If that is so, if the cancellation of any instrument, Your Lordship, be it sale deed or agreement, that is 3 years.
But he has not challenged the sale deed.
He has questioned the validity and legality of the sale deed, though he has not challenged. That sale deed is not challenged. And without challenging the validity, the sale deed in the plaint, whether he can, that is one question I put. The sale deed is not being challenged.
No, those questions will come later on. Now we are concerned with limited question of rejection of
Rejection of plaint.
Plaint can be rejected only under 711A to E. If any of the ground exists.
Lordship, I got it. As I have said, Your Lordship, if supposing the plaint is not mentionable under by virtue of Section 17 of the Act of 1965, whether the court can go into
the question
limitation.
Yes.
That I leave it to Your Lordship.
Yes.
But in my respectful submission, Your Lordship, so far as rejection of plaint is concerned, Your Lordship, now in my respectful submission, under Order 7 Rule 11D, Your Lordship, and read with Section 17 of the Act of 1965, Your Lordship, since the land in question has been acquired by way of through this acquisition proceeding, Your Lordship, the jurisdiction of the civil court is barred, Your Lordship. So, Your Lordship, there is no legal infirmity in the order passed by the London District Judge rejecting the plaint. So, no interference is called for.
Yes, Mr. Imsong.
Please, Your Lordship. Lordship, respondent number 3, 6, and 7, they are the, so to say, is a principal respondent. So whatever submission given by the learned.
You are adopting.
Yes, adopting, but I just want to supplement some points.
Yes.
Lordship here. The land, whether it's acquired or purchased, the landowner, those are the grandfather of the petition person appellant. They have received the money, whatever amount, 1,000, 8,000 or something. It is already returned and they sold it and the money received, page number 252 to 331. There's all money received.
Yes.
So now, after 40 plus years, the descendant or the grandchildren of those recipients of the land amount, now they come forward to the court and they are claiming that they were not paid. They are not paid. appellant, they have not received. There may be a minor or may not be born way back 1974. But dear grandfather, who knows great grandfather, have received that money against that land which is occupied by the present second enemy headquarters. So that is one. So also now the present appellant says that they have not received anything. No, they are not received, we admit, but we have paid to their grandfathers or maybe the aged father, maybe 90 plus years now. If a person, the landowner, happens to have 50 years, so will be around 90 years now. So who has a good health, they might be alive today. But I believe, and by going to the fact of the case and by going to the influx of the time, so whatever it is submitted, it is not trustworthy at all because the document is there. And again, the learned colleague has submitted, whether it is by agreement or by award, they have already paid and they do not deny. Nothing is mentioned about the denial at that receipt. Sale deed also is not, there is no denial. So after 40 years plus, nearly, according to our calculation, 1974 to 2022 is 40 years, I think.
52.
52. 52 years. So the person, the one who are alive, they may be the landowner of the legal heirs. So their grandfather, their parents have received their money. So that is another question. And now the appellant also raising the question about the non-rescission of the sale deed. You see, Your Lordship, as per the Registration Act 1908, unregistered sale deed, it has no value at all. But after 50 years, after Golden Jubilee, can I claim whatever my grandfather has done? Can I claim now? Can I deny? Is it possible? There is a law, concept of immortal litigation. Concept of immortal litigation. The court wants to go against that. The court wants to end the litigation, not to litigate. So concept of litigation means petal of litigation kept alive, which is contrary to the principle of law. So if the present appellant, the prayer the present appellant is alive, then definitely that legal petal will be immortal. Whereas those present appellant are mortal. They are mortal, their litigation will be immortal, which is against the principle of law. So now, whatever objection raised by the appellant, on a personal capacity, I should say, it is not relevant at all. And again, going by their plan and going by their petition before the learned trial judge. In the para 39, that is a running page number 50 in the present bill. They have indicated, means they want to say that the present suit is filed within the limitation period. So in order to, that is my suspicion, I am become very suspicious about the limitation here. In order to address that, the suit is filed within the limitation period. They have filed RTI way back in 2022, followed by, after getting the information from the RTI, they have filed this, they have issued notice under section 80 to the state respondent, and basing on that, the plaintiff has filed. So, by getting the RTI, that is 2022, followed by the legal notice, and thereafter, suit follows. Now, if you go by the limitation, and if you go by against the concept of immortal litigation, if you go by the section 18 of the Limitation Act, acknowledgement, section 18, clause 1 is very, very clearly mentioned there. If, may not be true, but if that was the intention of that was the hidden agenda of the appellant, to attract the court that the suit was filed within the limitation period, we have filed RTI way back recently 2022. But RTI was filed after the limitation was long time expired. So here may not be true, but my apprehension, in order to attract that limitation, had to file the RTI 2022 followed by the legal notice and again the institution of the suit. Then limitation Act Section 18 hits whatever acknowledgement should be made within the before the expiry of the limited period, so that they will get another life. A fresh period of limitation will accrue. So Section 18 is very clear about the Limitation Act. But since it is not specifically mentioned, but I'm going to the petition, I'm going to the clear plan. That is my personal appreciation. And if it's come that way, it is hit by Section 18 of the Limitation Act. Now, Lordship, I just want to submit one more. You see, Lordship,
Yes.
why so many laws are enacted by the legislature? A solitary law cannot. You see, a consumer law, those who are aggrieved, the right were aggrieved by the action of the service giver. The consumer law is there. And those who died in the citizen, those who died in the road accident, there is Motor Vehicle Act. In order to compensate their life, the legal heirs, there is law. But that consumer law and Motor Vehicle Act or any other law alone cannot go. As human body, a person may be very handsome. So Mr. A, advocate, his eyes is very good. Eye itself cannot. He needs an entire body. So also in the law, there may be some defect, but other will come in order to regulate the governance of the law. It comes in a different, enacted a different law. So if the contention of the blame is that unregistered sale deed, it is not value, yes, but under Registration Act 19, it cannot go alone. There is one law of limitation is watching over all the moving of the laws, procedures. CPC is there, Limitation Act is there. So also our body, our limbs, same thing, the legislation is doing that. So if they are blamed, again, give an emphasis on the part of the unregistered sale deed, then they're also up to 50 years. How can he achieve it? My grandfather, whatever he did, I cannot. And even if I can achieve it, what the hell the society will tell to me? And what there's a law to stop me. So that's the only thing. Now, the concept of immortal litigation, just I want to place on the Supreme Court. Basing on this acquisition of land and basing on the concept of immortal litigation, I may be allowed to place one judgment. This is 19 reported in 2024, volume 12, SSC 336. Lordship, this matter has been arose out of the excuse me. This is also acquisition of land. A plot of land was acquired as per the, for the purpose of the Liku Kanka project. Land was acquired, and there are so many landowners. So some landowner accepted, and the one who has come up to the apex court, he did not. And his grievances was made a reference to the competent authority, and thereafter, since he did not get a favorable order, the person appellant moved to the High Court. Then High Court rejected. High Court rejected his petition on so many grounds. And not satisfied with the rejection of the High Court, then the present appellant has reached an honorable apex court. So here, while deciding this limitation means under the Land Acquisition Act. So if you go by the para 7, the concept of immortal litigation is clearly mentioned there. Your Lordship, may I read?
Yes.
The law of limitation is founded on public policy. It is enshrined in the legal maxim, interest republica ut ser finis lacem. That is a Latin term, which means it is for general welfare that a period of limitation be put to litigation. The object is to put an end to every legal remedy and to have a fixed period of life for every litigation, as it is futile to keep an litigation or dispute pending indefinitely. Even public policy requires that there should be an end to the litigation, otherwise it would be a dichotomy if the litigation is made immortal, vis-a-vis the litigating parties as human beings who are mortals. So there was delay of 5,659 days delay. So basing on this, it should not be litigation, should not be immortal. So based on this, the Supreme Court has rejected the play of the appellant here in this case. So, Your Lordship, I incline on the para 5 to 14 is all about the principle of law, and the para 34 and 35. So the limitation delay was not condoned in this case. If the delay is condoned, then definitely that will be the litigation will become immortal. Again, I will be allowed to refer another case. This is also arose out of the partition, immovable property. So in the trial court, the defendant filed an obligation, like in the present case, under Order 7, Rule 11 CVC. They filed the petition, and basing on the provision of law, the trial court has rejected. And thereafter, I just coming to the shortcut only. Then the abortion high court, and ultimately the abortion ultimate court, the Honorable Apex Court. So that is para 16, 17, 18, and 19. So here, the suit was filed after 55 years of the partition. So in this case also, the Apex Court has rejected the delay. The condonation was not given, not granted. Delay was not condoned.
Okay.
So that is my humble submission, and that will be a supplement and my earlier submission of our colleagues. And as a human being, if we just imagine living aside all this, just imagine, even I cross 60, if my father accepted that land compensation way back 1974, might be a few thousand, 1974, a few thousand, and today market rate, it will be in terms of crore or in terms of lakhs. And now they are not talking about the money which they have received from their grandfather, great-grandfather. They are not receiving, they are not indicating even the receipt of the money, and now they are not receiving. The land was forcibly taken by the state respondent. It is a very, I see. It is not that, again,
Okay.
trustworthy submission of the appellant in the present case.
Any reply?
Short one, sure. Lordship, may kindly come to section 11(2) of the 1894 Act, because there something has to be clarified, my lord. Of the 1894 Act. 11 subsection 2, my lord.
Yes.
What is this agreement, my lord? This has to be clear. There's a clarification here, my lord.
Yes.
My lord, may kindly see subsection 2, notwithstanding anything contained in subsection 1 if at any stage of the proceeding, the collector is satisfied that all the persons interested in the land who appeared before him have agreed in writing, my lord, writing on matters to be included in the award of the collector in the form prescribed by the rules made by the appropriate government, he may, without making further inquiry, make an award according to the terms of such agreement. So, my lord, this agreement, let's assume that the sale deed is the agreement they're talking. Let's assume, let's accept the agreement. The sale deed is not a sale deed, though it is mentioned as a sale deed. It's an agreement under subsection 11(2). But what is this agreement? This agreement just has to be reflected in the award. That's what it says, my lord. Before him have agreed in writing on matters to be included in the award. So there has to be an award, my lord. And whatever agreement they have arrived at must be reflected in the award. Where is that? Where is that? This itself shows, my lord. So bringing a sell it and saying this is the agreement, so we have complied with the acquisition procedures. No, my lord. They are trying to better their case through these submissions. This has not been even pleaded in their application for rejection. This has not been, never been said. And lordship, just one page I want. Page 59, my lord. May I kindly see of this 59? Which these are the documents that was given to us through RTI, page 59, my lord. Yeah, type copies at page 59, lordship has found it. Page 59. Now, lordship, may I kindly see the type copy at next page, page 60. These are not my documents, my lord. They are not my documents. They are documents supplied to us through RTI, in RTI replies. They are the documents of the state. Lordship, land, on top of it, the heading is land purchase for the purpose of the second enemy. Land purchase. So, and then the sell deeds were given along with this. Then, so lordship, now, rejection of plain lordship has it has been submitted that abatements, all the judgments relied upon by the respondents, my lord. As it has to abatements in the plain has to be looked into, read with conjunction with the documents relied upon. Relied upon. I don't rely upon the sale deed. I'm not relying, my lord. It's a part of my plaint because I'm saying that these are the documents supplied to me, and I enclose that in there. But I'm not relying upon those documents. It's a document relied by the state. I'm not relying upon the plaintiffs are not relying upon these documents. In fact, they're disputing these documents. And the case laws that have been referred to is relied upon by the plaintiff in that plaint. There's a big difference, my lord. There's a big difference there.
Okay.
I'm disputing these documents. I'm disputing the acquisition documents. I'm disputing the sale deed. And insofar as the receipt is concerned, my lord, in paragraph 25, I've categorically stated that I have received they have issued me this receipt, but I've only received damages compensation, not land compensation.
Okay.
So, my lord. Lordship, the additional AG says human beings. That's what I'm asking, praying for. The state, mighty state, please, human beings, poor agriculture, farmers, please have mercy. Give us an opportunity to say that this land has not been purchased or acquired. That's all, my lord. My lord, even all these documents, we have not challenged the 1974 notification. Need not, because we were there in a civil suit, my lord. In the civil suit, all I have to prove is I have not sold this land. The government has never acquired this land. That's all I have to prove. And these documents, my lord, the documents they're showing here, each and every document has to be proved in accordance with the Evidence Act, my lord. It's not a writ petition. That's all, my lord.
Heard Mr. Imti Longjem, the learned counsel for the appellants. Also heard Mr. Imti Imsom, the learned additional advocate general appearing for respondent number 1, 2, 4, and 5. Stop. Also heard Mr. T.B. Jamir, the learned counsel for respondent number
3,
6, and 8.
and 7.
3, 6, and 7.
No, sure.
Hearing concluded, judgment reserved.
Thank you so
Much
much.
obliged.